Hey.
He wants some more. They want some more.
That's right. Shout out to you, McDonald Atto. We need to expose these people. I completely agree with you. Shout out to you. Na emisa eba choshi. McDonald Bacon again. The killing is too much. Indeed, the killing is too much, and there must be a stop to it. And that is why I like the way McDonald is set up. Preliminary comments before my boat near Kandemoni. And of course, it's going to be a long reading. Bear with me. Like I said, if you don't go into the nitty-gritty, it'll be an issue okay wale. Because in now they can yo, they can be now. One thing in realize Jakesi, these Uncle Ben, shout out to you, Uncle Ben, FAW. These judgments say it tells the story of a people Ojogban. So it tells us the story of la people Ojogba. Ka you osuma sanye e ba gbabo osuma sanye Ojogba. Eni bi me na me chombo ni fe ni shikon jie ba jia me de kenibi. And of course today you will hear a lot about Abola Piam. Now, two judgments. Jinoni e ba shende biane. Mene ene no fa because I consolidate three cases. So Sanonake, 3 different cases now consolidate now fail now. This was in 2019. No ni makanebo habo name. Ni once again, make explicitly clear. Okay, the Sowutuom lands. No mean ke wake magic bete onani wache ni adoto tinto a separate Omanjo dabi Omanjo ye no na cho le Sowutuom land say me. Omanjo it's not separate from Sowutuom. Omanjo get call na ni mo konta we separate Omanjo from Sowutuom land say monte ke ba ka o jemo o tu blown ye gamashimi. Jemo lante jangwe ye gamashimi. It is all part of it. You understand what I'm saying? And this judgment was between the Asere stool. Ni apparently up until nakantime ameto mancheme ye jame down before ke Abola Piam wekue. You understand what I'm saying? And of course, once again, Asere they were flawed. 3 different cases now failure come. Asere they lost all 3 cases. Ni judge make clear. I can be now make a baffin. They've not been able to produce evidence about support and a claim say judge wo fe the chaff. Once again, koni mo fe mo aneli ake. Ka ke Sowutuom shikon GF Abola Piam biano. So many about you hear about the cases about no bini claim keboni jeje a handle it. Now what masama babiyekum. So this is between Asere and Abola Piam. What no me and Kebaka of Afe rich in Yamakwe. She was fair rich in Yamakwe. I want to deal with this. You understand? There are more judgments, and I'll continue to look. Every document that I have, I don't care. If it's going to take me 5 hours sitting on my butt to read, I will read. It's a renewal of mind. We need to get to a place where you should believe and own what is the truth of everything. You should own it. And if we don't do some of these things, we will not be able to own the truth. People will tell us lies. Ni nobani wakawe be aba nobani mokoba kwa mokoyi and ba chaletu ni sani. Because this person has been made to believe in a lie. And that is why we will do this. It's about 50 pages. So now about 9 or 10 will be authorities ni aside. Kensha jame majie inkane na kind no mabo inkane na kind authority say mabo majie no me and then we'll go into the substantive nibia denche because authorities have a quote in the case no jame inkane. So we'll go down to about 40 pages. You understand what I'm saying? Like I said, kaja mankeleni imboy ni chumo ini de shano lebi no so media nche inako de ka ni makanele thoroughly so my body usually coming can cases in your boy in na de can your words come ye me mfi osho aka nu shishi inu osho but this one I haven't done that just in can in brush through a few pages ko kekepe then go straight to no ni jeje na agbe. So you and I are going to read this together, you understand. So of course some of the Latin any inu osho mo I will explain if I have to. None many we'll just skip over it and move on. But once again, to the best of our ability. You understand what I'm saying? So now, war is going to be between Sempe and Abola Piam. I have another judgment. It started from the early 90s. So 1990 noko Biamini ni adoto obwo was manche or sempe. Bona ni abagbena in 2017. So it took over 20 years, about 24 years now dealing with this particular case. Once again, Abola Piam I'm a floor sempe me. So hear this and hear this now. Get a balesio tom shikon GFA Abola Piam no. Asere Joshi, I'm a benoko klom game. Yes. And I make Abola Piam be a short boundary in certain areas and I can no. Yes, judgment dear na short boundaries, yeah. Judgment make it fair and clear. She can a balance Shikonji na chole Sowutuom Shikonji. Know this and know this well. Abola Piam no sempe Shikon Benjamin. Asene Shikon Benjamin. So manche ni Sowutuom Shikon no. Ni represent sempe naka manche is illegitimate. That is just a fact. Ni nekeno kone no nike gbomogbe many afe no na ma afe ya omanjo. They are from the Sowutuom stock. Ni I'm a representative sempe. The Sowutuom stock. Ni I'm a representative sempe. I'm a webi na me te omanjo. Ni I'm a creating I can trouble. Meanwhile, Sowutuom shikbo yes sempe no mi. Jemi nke court to decide. So keji asene ya manche ko yeme asene manche is illegitimate. Shikbo je asene no. Ke sempe ya manche ko ye Sowutuom naka manche is illegitimate. He is illegitimate. Sowutuom shikbo GFA Abola Piam bi anomi. Je te ko tuluwe no. Ni Kevin Taki e kante. Kele e kropon baya na me ba to Solomon Atipo manche. And these are the reasons when you watch one money. You understand what I'm saying? I've been thinking about this and this and this and this and this that I have to send a voice note. You understand what I'm saying? This has taken over our life. It has taken over our life. You heard Ayabache tearing up. He was tearing up. This has taken over our life. Any what Lebi Shwane Beke. This is all we do. Thinking about yes, mankenele chanaka inka akuche mwe yue manken yebie inka akuche wa yue pi wo so wa eche mokwe wata mokwe fon wa ba bie ni wa ba wo mokwe muji wa ba bie ni wa ba pata moko hie si elani yo gadangbe odido ne sani wama nike wama ni wonue e ba cha na kan hela na ka odido anukwale dido ni chameni nye woye efia me yake anukwale odido amema ni no ewo ni wota bia ni won ka make chame nyema anukwale odido nyema anukwale odido amale odido gbegan patanga fitegan yin. So nyema anukwale odido ni wafe wanu ni wayajo. Kanye batashie koniga ko mama pepa na ebu Kenya batashie koni ga ko mama papa na ebu mama papa aka male efe mama papa aka male efe mama papa Ike mama papa aka male efe mama papa. Look, as long as you lots will continue to lie, as long as you lots will continue to be hypocritical, as long as you lots will continue to be evil, wicked, perverse, and mama papa kokula be ni gababu. Mama papa ekokula be ni kenye nabu juo keke ne nabu ni nyeke yuo nye pure wa lip service ka ba dumoshi ni wa fe wa yake neke ko na mancheme ne dumoshi wa fe wa yake neke ka mancheme ne ba dumoshi ni wa fe wa yake neke nye fe ko nye yi noko lip service so nye ba player, and you have the gullible ones falling for your bullshit. Total lies. Amale so nyeba kenyeba nyebe play and once again this week bo because you are a disgrace. You are a disgrace. Ebo is an akpabo. It's an abola biya ame kpabo. Sanabola biya ame kpabo. Because I'm watching this video back and I'm watching you sit down. Abola Piam in Shikong. Nimokone represent Sempe. Echume na Abola bi no. And you are sitting there just like that. You are sitting there just like that. Bo ke ka bo kometo ni bi abako. Asana kpabo. Say no more boy can Abola bi. Bo under your watch Abola Piam Abola Ajami. Ajami. Say na kpabo. Say no more boy. Bow your head in shame. And watching you sit there quietly. Bo ke paramount chief jibu. Ni ke bo ato manche. Ato manche under you ni o agree. Ni think to kometo you. Ni think to make it clear ake. No you are, it's a collective decision from the traditional council, and you are sitting down. Many ke oman jobi e ba fe ni ameje the Sempe stock. Sempe stock any your Sowutuom ame ni shikpo oje Sempe mano. What is your usefulness? No tagane. Johnny Femo, Kiamoko. Shout outs to you, Mangi. Shout outs to you, Mamele. Shout outs to you, Uncle Johnny. Shout outs to you, Amani 90. Welcome to the platform as well. So, what fe Joanna Kwe ke Richard Nyama Kwe? What fe Sempe ke Abola? Mene wan fe Asere ke Abola. Nyoni ake mo fe mone challenge Abola Piami. Yes, Sowutuom shikon here. Eluzu pato. Abola Piami e floor me fe. Esani moko yo mancha yes Sowutuom. Ne Abola Piami be etole. I repeat it again. Anybody ne ka manchajile yes Sowutuom shikon jiano. Ne Abola Piami be etole. That person is illegitimate. Ni so-called Abola Paramount Chief ni nunu etajeme ni atalebolu. You should be distilled. Esanibo Abola biya amek tabo. Ni adoto tinto etanshi. Ni ake Sempe bafe nake. And you are sitting there in the name of a collective decision from the traditional council. And you are sitting there. Ni ake bo Paramount Chief under you. Na ake bo shikpo. Ike Abola biya fe kome na amek tabo. Se na mo boy. Kehame. Bo kwashia ni last time mi we ni ane sane no ba kake ba no ba type ni lulu keke. Ona ka ba tabia wo sumo ni wo jaw. We don't want to use na kind words, but some of you force us. Ni lulu. What is the use of a Paramount Chief? Minister na mo yo keji etashi. Ni somebody from a different paramountcy. A creating mess ya le shikono. Ni a me ball can pashi. Once again in Gabo. Keji oye Abola Piam. Keji o Judgement. Ni bo o fe Kevin Taki Oluona. Isani jema waji ni Abola Piam. Sisai ke majian cheme na sana me kocho na me ke chokwe se no gbo. Sani ame kocho na me ke chokwe se no gbo. Because you are selling them out. Every single person, oh yeah, Abola Piam, Nibo Ofio Kevin Takie, Bo, you are selling your forefathers out. The toil and blood of your forefathers, you are selling them out. Abola bi na pani esaninye pale. Pani saninye pale. Esaninye papani. Se na mo bay. Saninye papani. Se na mo be pani. So here we go. Nyani. No, you ain't tower in Kebele. Yeah, 1 second. Nimba. Doc, here we go. Yeah, me 1 second. I did already. Is it this? Okay, let me choose this. Let's see. Continue. So, to many Kenya, waba botemi. I don't want this. What are you doing? Okay. Here we go. Yeah, 1 second. Nta magbele ye. If you can gbele ye be and if you're easy army, but nshmo magbele ye be ye. Yeah, me 1 second. Yeah, me 1 second. Let me try again and let's do this again. Continue. It's crazy. Okay, I guess we'd have to go with this. Unfortunately, the other place, so now, let us reading. Ni wabotemi Jani Femo Kiamoko Prince Worthy to your turn. Bet Oyojugba. Amanike is afraid of Nisimpe because Akrashi knows is not the Abola paramount chief. Court has already declared. Nyekana kan wolo ahami. Imbe na kan wolo ebie. Mi tau na kan wolo nyekana kan wolo ahami. Nyekana kan wolo asendi ami. Nye fiale PDF nyeka send anyway mabi matau. Akrashi yes, he's as useless as they come. Look, cheme mi ikonye dana ke je no womo mi ni tete je no mi ke olemi mo fe ba ke ebo mi je no womo nke no na eyin noni eyin cheme ke nyeme noni eyin no na eyin no na eyin. All right, so let's go in. No one is sumo owner. Yeah, me 1 second. Let me try and work this thing out properly. Bona. Let's me 1 second. Ni what abo ni e kan de mo no. Kefie na ke na ga fe le bibio ni insumo ni ke e fe le bibio na kan ke fe insumo. I don't like it. Insumo na fe agbo. Ke ona ke ona le ojogba. Nlia ke the same thing. Okay. Miss Monica, if you have book, if you have book, I mean, can you get onale ojoba the enche? If not, we would have to go with Bonnie Wabanale Bona. So nyami one more time. I don't want to copy this link. Okay, let's try Google Docs. Let's see. Ni wabotemi ojugba oba botemi. Like I said, sometimes it tells you the story of a people. Oba na ena jeshi na ba ena je na ba toshipon me ni me ba toshipon ka ke hamoko boni bana chona ke hamo. It tells a good story. Ni onu ni bi ashishi ojugba. So mene oba na ake Abola Piam bi ame wo asene me echafun. Wo oba ya sempe me umba. Le unke ba na kansani agency 19 loko unke bata 2017 na agbefen na ye appeals court Abola Piam bi onwu ame e chafon moko cry challenge ko Abola Piam bi ye ne ke shipon ne ni mo e succeed moko cry challenge ko. Okay, I guess we'd have to do it with Bonnie Wabaya Lemene. So let's use this one because one check. Shout outs to you, Nishipi Ofanebe Oye Ojoba. Okay, let's see. Good. I think this should be better. Google Docs should be better. Minta noni obanale ojogbang bona. So noni eani kekemi. Let's do this. All right, let's deal with this. I think this is the only way ni wobanale. So nya waya ale na kai bona. Was blashi. So let's just go this way. Now, Chabe, you find it be my eyes. Can no connect anima na nya animali aye WhatsApp onu because I will not be on this screen. Nya waji ashishi. Let's go. So to mobeni kebwe consolidated cases ne obana upper right hand corner ye be a trouble BL 19-2010 TRS, another one BL 143/2005. So these are three consolidated cases. Ni aye ni fe shikonji na yo isani fe e call Sowutuom so nyani wayano. Now so ona be see this why I don't like this this particular. Maybe you say they were let's see. Okay. Ona be ni tafo among le ejesani ashishi ni choice money substitute leji Clifford ni amon kote per his attorney Festus ni gwe so ke ona no obana ke. Now sanene aseneme ni kete once again sanene ni makane mahabwe je Abola Piam bi epo ni ameke o akọ ameshipon ni ama amekete dabi aseneme ni ameke sani ete keshi Abola Piam bi na me lose. So now Abola Piam bi time ego na aseneme wo sani ekete court na te ama lose toto. So na ake ame ni tafo amon ni jenyo deceased number by substitute le Clifford ni amon kote Richard Kote Addison like the second applicant versus Water River Authority. So na kanjeme be Water River Authority I'm a cost shikon jiye ko na it's na me pay compensation. Ni na me pay compensation Josh bi eke shikon ma me no it's na pay compensation ya Abola Piam. So no wo ona Water River Authority ame yejeme ona ke second person G wache ni Yaya Ade. I did this. Watch ni Yaya Ade, head of Abola Piam family. Watch ni Yaya Ade and Ke Yolo. Egboko, Yolo is still alive. Bona. Number 3, ni Oma Minsa Family Limited and ni Tafo Amon the second. Another one there une bona. So ben kaba case is a pini a consolidated case is I'm trying to see. but I don't like the way they chon be. You find in your me. I have a way Nick if you're like easy a hammer. This is a little bit crazy. Bona boni ni yo. So ona nyam 1 second. Okay, here we go. Another one there, versus hour of visitation, Dr. Isaac Abebio. So these are 3 cases. Ni aye ni fe make le clear ake shipon Abola Piam be ano. Now judgment. Yani what the so this one case any start 2006 no junoni wababo in Kandemone. Okay, on 24th April 2006, the plaintiffs in this case, they are the courts ni onani wakanie ni among court take a Richard court take no nani wachame be amameji plaintiffs issued out of this court a writ of summons with accompanying statement of claim, which was amended on 4th January 2007. And further amended on 7 January 2011 against the defendants. So the defendants say, "Oh na Abola Piam wekuicho niji wacheni ya yadi unegbe ejeme ke some other people una ejeme so nkeba ka seneme ni ameke sandene ti nike 3 cases na consolidated aseneme nikete." Manager reliefs ni they were seeking for. Let's go on. A declaration. Hey, I hate this thing, man. It's gonna be a little while, but nigga warrior, we'll get there. A declaration that all that piece or parcel of land bounded in the north by Asere's 2 lands, measuring 15,600 feet, more or less, or bounded on the northwest by Insaki River and Mukose or Mukose, Mukose land measuring 10,300 feet more or less and bounded on the southwest by Mukose lands, measuring 23,200 feet more or less bounded on the southeast by Mukose and Onamakro Adain lands, measuring 13,600 feet more or less, covering a total of 6,698.726 acres more or less. So J Shomo Shikon Sanya, you're close to 7,000 acres of land ni akeneke shipone sani akete kote. Now egamini an order declaring the statutory declaration registered as number 1529 null and void ab initio. From the very get-go, I mean, cannot go ake neke declaration and they can neke shipone. I believe ake in this case we can say ake neke registered declaration was in the Abola Piam way. Ni Asere bi eke court a declare from the very get-go as an disregard esana ke no chwani nkla. Recovery of possession. Koni shikpo GFN Abola Piam bi e call koni court we aye amedi ni akaya me aseneme. Damages for trespass. Agbenenwe aye damages against Abola Piam bi ake je ameshiponi ni amete shipon kono ni je ameshiponi no afine amehu abo amenyumo. Now perpetual injunction to restrain the defendants themselves, their previous assigns and workmen from entering on plaintiffs' 2 land. Okay, keji court to a fene me fenwe koni astopu Abola Piam bi ake amedienche ame wombi ame nichuloi fe ame tebo komoko kula ake ya neke shipone no. We are talking about 7,000 acres of land. They no go be you once again. Okay, finally I cost a harm. Now Miniji I'm a statement of claim ni amekaba yani waboti ami. Nyami 1 second. In their statement of claim, the plaintiffs averred as follows. The first plaintiff is the acting Asere Manche and Jaseche of Nikolai's Stool of Asere, and the second plaintiff is the head of Nikolai's Stool of Asere. So many kesani ete amene so at the time Asere Manche at the time ke Nikolai wekue ameicho ni acting Asere Manche at the time ameni amekeneke sanenete keshi Abola Piam biye. The plaintiffs brought this action by their respective attorneys. First name Benjamin Nikwe and Joseph Emmanuel Ahiaka Nikwe. So now Joshi B no G I'm a lawyer. Now The first defendant is a corporate body established. So bear with me. Okay, hello, maybe I should use this. Let's see. Okay, this is better. Okay, now again. The first defendant is a corporate body established under the laws of the Republic of Ghana, and the second defendant is the head of Abola Piam family. So once again, on the defendant say Volta River Authority. We know them. Watch it near Yadi. Ameji, the first and second defendants. Let's go on. The plaintiffs, Niji Aseneme, they brought this action on their own behalf and on behalf of the Nikolai Stool of Asere, who is the allodial owner of a large tract of land described in the schedule attached below, including the disputed lands. So Aseneme ni amekete kote ake nekeshiko jine fe amamenoni. Let's go on. The plaintiffs state that being the allodial owners of the said land, Nikolai Stool of Asere has been in uninterrupted possession of same from time immemorial. Aka me Aseneme nekeshiko ne na kajobu ade amamenoni ne ya mede. Mokomoko ka me epele ko is uninterrupted. The plaintiffs aver that various judgments from the colonial days up to present day confirmed the plaintiff's stool as the allodial owner of the land of the said land, including the disputed land. Ameke colonial era keje blofo me bi amini blofo me yo wonoton aye sajin pi ni neke sajin na efe le fan ake neke shiponji na efe asene ma noni. Now, yeah, 1 second. Watch out. The plaintiff further averred that the disputed land is situate, lying and being at Sowutuom. So Nyambotwe. Under the care of Ni Afutukote, a sub-chief of the Nikolai Stool, whose successor currently occupies the stool as Sowutuom. So once again, Biane wanna I introduce Sowutuom. Okay, Shikojine is over almost 7,000 acres now. You are fair a Sowutuom. So I introduce Sowutuom keba KSM agbene vividly one ake. So Shikon now you are Shikon about 7,000 acres. Ni a Sowutuom. The plaintiffs also averred that the plaintiff's two family, being the owners of the land, including the disputed land, and received several compensation claims affecting the land. I may receive compensations, baba. Oh, yeah, no. The plaintiffs state that the plaintiff's tool admits several grants to third parties, some of whom are developed same and others are still developing. Okay, shikone pi. Ni me mamo ni bi yeno ni amotone na meke sani e bapodi enche ameke shiko ame kome ni me mamo ni bi yeno. The plaintiffs aver that Volta River Authority, the first defendant herein, is unlawfully claiming part of their land at Sowutuom, alleged to have been granted same by Abola Piam, the second defendant family. So ameke neke shiko ne ni kajobu ade wa noni ni wakeha me ni me ma Volta River Authority ama men claim ake shikon ama no she ame wodi ameti ama Abola Piam bia aden ona boni ni ayo Abola Piam bia de gi eni ama he neke shikon ne ya mede ni nakan no esa nakan. The plaintiffs aver that the defendants are relying on an alleged self-serving statutory declaration, a secret in a secret document between the defendants to be the basis of their ownership. So neke no kone na Abola Piam alo VR bi eke amame no ni Abola Piam bi eke woloko ehane ni nakawolu anojino ni amedumo ni amenkake neke shikon ne amame no ni. Now, the plaintiffs aver that their intention has recently been drawn to the said recent statutory declaration based on which the defendants are claiming part of the land. Akeneke wolone ni Abola Piam bi ekechon via Volta River Authority. Ni no wana ameke shikon bi ana me Abola Piam bi adene. Pakoda ni ame asene biye amenine amedwomo eba na kan wolu eno alo amenine ehye na kan wolu eno. what channel? Again. The plaintiffs state that title to the large tract of land, including the disputed land, had since long been confirmed in the plaintiff's stool. The allodial owner and the self-serving statutory declaration does not supersede title. So I mean, chono kwake, neke shikone, kejo kwe, ame wojame, can be fake, kajo boade, yanibi amiake, ama seneme, ama menoni, no neke title ne, ni Abola Piam, bi alencha ya create naka no, enye, eho, neke wojine, ni amenye, hey, nyawa chano. The plaintiff also stated that the defendants are trespassers onto the plaintiff's land with various attempts to disturb the quiet enjoyment of the land by the plaintiffs and the grantees. Okay, no, I never baleneke wo. Abola Piam be ame trespassing. Ame ba eko ni esani ame ba. Ni no ewo ame taw ni ame fite to enjoy. Ni me ni be asene me won shikpo ha ame enjoy yo ye na kan jame. Now, both way, the plaintiffs aver that Sowutuom is the settlement of Nikolai Asere, who are the owners of Sowutuom and have ruled over same from time immemorial. I'm again Sowutuom, manena yone. Nikolai, ni leji asene fenche, le shikoni, ni le eshe asene me, ni asene me eyino. Afi ohai baba o neni anya kaipo since time immemorial. Kaja jensa asene ma shikonji na kaino. The plaintiff further averred that Abola Piam family have never settled on Sowutuom and cannot point or show any act of settlement in Sowutuom. Okay, Abola Piam be there na meba. Ni ame ko ake na ke Sowutuom shikpon na ma no. Ame yiko Sowutuom shikpon no da. Ni ame nye ni ame chon. Ake ame nana shushui ame nana dadai ame cheme eba hinjeme po na ame nya ame chon no ko ni chon ake ame cheme po eba hinjeme dan. Too much. Yeah, 1 second. Okay, what can it be? Let's go down. Okay. Yeah, 1 second. Okay, now what channel? The plaintiff further averred that Abola Piam family have never settled on Sowutuom. That be in Sowutuom. Boli ni be come kati so blofo egbe your to me neja konu blofo bana keja and cannot point to any act of settlement in Sowutuom. The plaintiffs averred that the said statutory declaration affecting parts of the plaintiff's land is fraudulent, illegal, and therefore null and void and should be expunged from the record. So I mean chono kwake neke wolone ni Abola Piam bi enye ni ame ko ake no ni Sowutuom shikpon ama ame no nie neke no eji fraudulent in this case take them akelete eji no koni ame na ken wolu ye gbe papa no ame chung be phone no ni ameke na neke wolone na amenye ni ameke wolu ewo ama ame shikpon ni ame chung be phone no ni ameke na ken wolu no wo na ken wolu na anye court abula ake na ken wolu je wolu papa ni kone ewo wolu na chafun. Paragraph 18 is attached. Now, but we I'm about describe shikpon once again about describe the land in dispute is bounded on the north by Asere's two lands, measuring 15,600 feet, more or less, and bounded on the northwest in Saki River, and Mukose lands, measuring 10,300 feet, more or less, and bounded on the southwest by Mukose lands, measuring 23,200 feet, more or less, and bounded on the southeast by Mukose lands, measuring 11,320 feet, more or less, and bounded by the east by Mukose and Onamokro Adai lands, measuring 13,650 more or less, covering a total area of 6,698, 726 acres or less. So almost 7,000 acres. Now, because I'm alleged fraud there, it's an I'm alleged fraud there. So particulars of fraud and illegality. making a statutory declaration registered as number 1529/69 on the said land which is not a settlement of the Abola Piam. Okay, once again, neke land there na me register ya me ba mi na kai no jama me shikoni. No ke jama te na ma register neke shiko jine fe ya me ame ba mi ame fe ni fon na kai no esani akamaye. Registering the said statutory declaration covering a land has been declared by judgments dated 13th August 19 suit number 10/1947 before Jackson J. Jackson J. And between me, Amasa, Nikoi Olai, and other claimants and others in favor of plaintiffs too. So I mean, Koti. Sanekoni neke Justice Jackson J ne Kenya bakwe most of the cases any what can your friend at a colonial era ona neke Jackson J ne ni your a lot of these cases wa dienche onake colonial era time expertise ji neke shikon sajiyeli ne. Now B dated 22nd November 1951 seal number 31/1948 before Jackson J. And between Ni, Amasa, Nikolai, Nico Olai, and James Adams and others. So once again, I quote. So Amasre Joshibia, these are all the cases now in Kemba. Ni Amenkake, Aye Sanjin Baba, oh, ya Nekeshipon Jine Fe, Nekeshipon Jine Fe, Ehani, Asere a grant to Ame claim to Noni Amefio. Another suit dated 14th May 1962, suit number 221/1961 before Mrs. A.R. Giage J. And between William Nikwe Kote and Bole Odwe and other judgments in favor of plaintiffs too. So I make court neke cases all the way from the colonial era to Mobena Mechon ni Ayesani Agame ni ya me susumomie neke sanjine fe e me clear. Ake shipon amameno. Once again, so I mean chono no wani ameke Abola Piam be no na ameke ba is fraud and illegal. Fraudulent and illegal. Number 3, deposed to untrue statements on oath. The land is not stool land, with the full knowledge of the fact that the land is a stool land belonging to the plaintiffs too. Ake Abola Piam be enwe amemale under oath. Ake shipojine na you je sen ko shiponi ni ameliake shipon sen shiponi ay sen shipon ni ay weku shipon amege sen shiponi Abola Piam bi ame weku amega ame weku shiponi no Josh bi ka Abola Piam bi ame male ameliake ne sen shiponi je ame weku no she ame male under oath ake neke shiponji ne ame noni. The plaintiffs state that the land in dispute form parts of the plaintiff's stool land and cannot be lawfully acquired by the second defendant, and any grant made to the first defendant is null and void. So, I mean, Kakadabi, Shikone, Kokwa cases, ne fe, ni wachena, yeke, the colonial era fe. Clearly, a Kabwake, Shikone, Wawanoni, the Wakaji Water River Authority. Eya he neke shipon ya Abola Piam ndie no ele je wo isani amenya ame claim shipon because wo shiponi ni keno wo isani wo ha me wo isani wo kan ha me je Abola Piam bi the plaintiffs in their reply and defense to the second defense counterclaim averred as follows. So still there were plaintiffs say no about defense say ja me no na me keba. The plaintiff joined issues the defendants generally in their statement of defense. The plaintiff denied paragraphs 4, 5, and 6 of the second defendant's statement of defense and counterclaim and say in reply that it was rather the second defendant's schedule that has no dimensions and proper description. So, when I print le hamie no junoni wanane shugweni nkanejame is any one defendant saying what they were going to say to make claims then after about printer a flip around, but bear with me now. The plaintiff in further reply stated that the disputed land is not and can never be ancestral land of the second family, the Abola Piam. So once again, I mean, you can look. Shikpo jine ni oje me fe Abola Piam bi I mean, nya me kake ame weku shikponi. Wa sene me wa say shikponi. The plaintiffs, in reply to paragraph 5 and 6 of the first defendant's statement of defense, state that the Abola Piam family, the second defendant, cannot make any valid grant of the disputed land to the first defendant as they do not own same to have granted it to them. So, I can indicate shikone Abola Piam woku eji amame no Simon wasene Josh saying wasene biye wa saying ni amenya meka shikon e mokonklo. The plaintiff vehemently denied paragraph 7 and 8 of the second defendant's statement of defense and will put the second defendant into strict proof of the averments contained therein. Once again, I'm trying to work at no need defense. I don't know Abola Piam be a paragraph 7, 8, 9. Can no name ma fe I make a fair party ni I make a proof baba ni na kano awo achafon. The plaintiffs in further denial and in response to paragraph 7 and 8 of the second defendant's statement of defense and counterclaim state that Abola Piam is not a branch or part of the Tumawe family and have never migrated with them from Ayawaso. This is very interesting. So another thing, Obanake clearly defendant saying claim it yake. I'm Abola Piam be I'm a fita Tumawe bi na meke Tumawe bi je Ayawaso keba Joshibi again dabi no na me yue ebemi Abola Piam be I'm a fita to my webi ni aje ayawaso aba I'm a fita. This is not Joshua be against Abola Piam. The plaintiff also state that the land in dispute forms part of the Alodia land and that the second defendant never migrated with them to have settled on same. Okay, yes, Abola Piam be keji ameke ni aje ayawaso eba I'm a fita in aba I'm a male I'm a fit na aba ni na aba insuoto mu ame be mieko ni aba insuoto me no amenya ameka ke na kan shipon ama menoni. The plaintiffs in response to paragraph 7 and 10 of the first defendant's statement of defense state that the statutory declaration is secret and self-serving and has no notice on of its registration or publicity had been given to enable those who object to the claim of the declaration to have the opportunity to file their grounds of objection. Akaneke wolone neke registration na Abola bia ya fe ame fe ye temomi na ame fe atan ame ke wo papa no ni mo fe mo ba na boni afe ni ke mo ko ye no ko de ba awe ye ni mo anye awe ye ni Abola Piam bia ya fe na ame ke wo ame kotoku emi ame deny Joshua bia an opportunity to go against it. The plaintiff state further that the land's registrar, who is alleged to have registered the statutory declaration, never gave any notice of the lodgement of same. I can land registrar ni a register ne ke shipo ne ke Abola Piam bi e ke no go wo maintain ni mo fe mo ba kan ya ke o ne ke shipo ne aba register ye Abola Piam be mi. The plaintiff also state in response to paragraph 10 that the mere registration of an instrument cannot be pleaded in any court of law to answer to a question of recovery or possession of the land if the grantors have defected title or have no title to the land at all. Again, go register shipon ni title bay na no konye title or no register shipon chike title bay alo title e bo gba ni onye oke akotu no akake be shipon bo no ni. The plaintiffs also state that the alleged registration made under the Land Registry Act 1962 Act 122, etc., does not confer the state guaranteed or indefeasible title on the grantor who has no title to the land. So I mean, chono kwake na kaji okwe Land Registry Act 1962 Act 122 if ele fang akena even though Abola Piam be a register shipon she am a be title you know niaka am a be title you know. Nakano anye VR I'm a care VR because call be title forget it. You can have a registration. Call be title registration no nye no echonoku. The plaintiffs deny paragraphs 10 and 11 of the second defendant's statement of defense and counterclaim and will put the second defendant's strict proof of the averments contained therein. Amekake yes, paragraph 10, 11. Ni second defendant in this case watch yayade keba ame yenibi ni ame ba go na kan no fe echa afon. Let's go on. The plaintiffs in further denial state that the Ni Afutu installed recently was the Ni Afutu the second. There was the Ni Afutu the first, no more Afutu Kote, who even litigated over the Sowutuom lands to the knowledge. Okay, Jamen eche. So I mean cholo wage neke ni afutu ni jienyo ne leji ni afutu ni jienyo ni afutu kenkle leun eba no yeneke Sowutuom shipon jine no chwake ba mekane wo jani chwake kaji wana ni afutu kenkle wato manche jeme omo ni afutu kenkle ni eba no yeneke shipon jine ye ni wasa wato ni afutu ni jienyo besa no na kanu ni wayu anokwale ni. The plaintiffs deny paragraphs 12 of the second defendant's statement of defense and counterclaim and will put the second defendant into strict proof of the averment contained therein. Once again, paragraph 12 of what second defendant elegi what ni ayadi. Paragraph 12 of a defense nekeba Josh Bieke ambawo no achafon ame proof ni amebawo no achafon. The plaintiffs in further denial state that the Abola Piam family do not own land at Sowutuom. For the plaintiffs who are the allotted title holders of Sowutuom lands to have been said to be selling same illegally. Okay, Abola Piam be ame beshikpon kokra ye Sowutuom. Ne wakeji amete ni ame on shikpon jinkomi yejeme beshikpon na ame on ole ye jalemi. The plaintiffs say further that general documents have been given by the allotted owners of the Sowutuom lands, which have been duly registered by the grantees of the plaintiffs. So once again, okay, Josh Bie, I can shikpo wa no, wa shikpo ame babao ni wa ha me wolo ni ameka register ni ama ameka register ne ke shikpo ne ni sande ko buy. You see how useless our land system is here, Ghana. It's useless, it's corrupt, it makes no sense. And that is why we continue to have some of these issues. Yeah, Shibami, Jani Femo, Kehamoko, Lilewu Ekehamoko, Ami Gonti, Noni Yangweko. We're going to read and read everything to the last letter. Then we'll back bina. One way in Kesempe ma no baba. Kesempe me ye no conclu. Ni efo wono ni makane ye mi amekeba ka amekeba makane inye me asene me ke amehu ameye no conclu ni no ni kan yo menene efo no ni kan yo menene mi asene me hu keba makane koni no fe no afe fan amofemo ka asene me keba nta no because me nta ma push mo go agenda no so ka asene me ye no ko after 2019 ni judgment ne kan yo yan abo e wo le chafon inye ma sene me nye ka bai nkenye fe yo jeme Josh ke chono no ne 30 seconds walk ko je chono no oba she Josh 30 seconds nye ka ba makan ya ma anya inye me sempe me kenya unye ye noko ni wo makan ye after 2017 ne ka Sowutuom shikpo nye no nye ka ba makan ya sempe ke chono eje ke nchon fo jian mi no machon iyo mwene ehon fufun iye pe egbe no ke nchon eje no be no ana no ya je to icho enye le to icho na hon fufu ye je me ke nchon to icho ni nteyin efio no eke be ke nfe right no ma je ena shan lo ye freeman bi aso mo tun ese eke ke nfe left no na no sempe ise sempe o na boni ni yo so nje ke from chono eni yo e chono to sempe 3-5 minutes walk no nshejeme beme komeji wo ife moko agenda e bie ko ye wolo ni no ni kan ye ba wola cha fon ke ba makale maabo. The plaintiff vehemently denied paragraph 14 of the second defendant's statement of defense and counterclaim and will put the second defendant into strict proof of the averment contained therein. The plaintiff in further denial state that no notice or publicity of the statutory declaration in question had been given by the declarant or the land registry who is alleged to have registered same and will challenge the second defendant to produce copy of the said notice of declaration. Where NMF lawyer for no go come about blaming to move for. Same thing. Okay, once again, ni Abola Bia register shipon, Abola Piam Bia register shipon, amefe le fan ni me bana, ni ke no ko ye mo aba yue. The plaintiff in further denial, once again, 20. The plaintiff in reply to paragraphs 15, 16, and 17 state that the fraudulent registration of the statutory declaration cannot in law confer title in the second defendant. Okay, Abola Piam be ama register ne keshiko jine ya male mi na ka meke. Abola Piam be a register ne keshiko ne ya male mi na ka no amenya me kana title. No na amenya me kana title shiko je amame no. The plaintiffs in reply to paragraphs 18, 20, 21, 22, 23, 24, and 25 of the second defendant's statement of defense and counterclaim state that Sowutuom lands are part of the Mukose land belonging to the Asere stool of which the plaintiff family is a member. It was the plaintiff family who even granted Chantan land to Naiwe family, which is part of the disputed declaration. So I'm in Chono Gwake. Noni watch ni yaya ade defense ne kaba. Yeah, paragraph 18 kata 25. No na me you of J correct ni. Aka Sowutuom shikon efita shikon jiye na chole mukose shikon jiye. Nineke mukose shikon jiye asene ma shikon ni. Nineke mukose shikon ni mine no po chantan yemi. Ni chantan ama asene me ama mekena na ewe wekue. The plaintiff denied paragraph 26 of the second defendant's statement of defense and counterclaim together with the particulars of fraud. So I'm going to there and I will put second defendant into street proof of the averment contained therein. So once again, I'm a paragraph say I'm going to deny no ni Abola Piam be you and the paragraphs ne fe I'm a proof ni I'm a no fe achafon. The plaintiffs in further denial state that the various judgments referred to are in the public records for everyone to access and are ready to tender same in evidence at the trial. I can cases na me chefe aka ye na ye ha me ni fio Sowutuom shipon aka me Joshi bi ama sene me ama me no nie na can no fe ya mami mo fe ba anye court say no town na can no fe obana. The plaintiffs state that the defendants are not entitled to any of the claims against the plaintiffs and same should be dismissed. Akana Abola Piam be na no na me you ofen awo fen achafo ame be no koklo mo kwa ye Sowutuom shipon sanene na yo. The plaintiffs averred as follows in denying the plaintiff's statement. Agbere so ne be nkan ye na fe me je no ni Abola Piam be amo ame you ye. The first defendant makes no admission to paragraphs 1 and 2 of plaintiff's claim. Aka number 1, number 2, save that the first defendant is not in a position to state who the head of the Abola Piam family is. Defendant admits paragraph 3 of plaintiff's agreement. So once again, I'm sure I can know VRA. They are not in a position now. So they agree with none plaintiff say you are. Paragraph 4, 5, and 6 of the averments contained in the plaintiff's claim are categorically denied, and plaintiffs will be put to strict proof thereof. Okay, I'm a Asere Joshi be I'm only be now me I'm a woluemi. Yeah, paragraph 4, 5, 6. I'm Abola Piam be I'm a bawo fair achafon. I'm a nomima ni I'm a bawo na can no fair achafon. Save that first defendant admits that the land in dispute is situated lying and being at Sowutuom, a suburb of Accra. Paragraph is denied. Okay, once again, noni VR be a care. I can again no kone Sowutuom, the suburb of Accra. Naga no paragraph no ko jame fu jame no. I'm in denied naga no fine. Now, first defendant VR Volta River Authority. The first defendant denies paragraph 9 of the plaintiff's averment, and that even if the plaintiffs have made several grants to third parties, these grants are void since the plaintiffs are no title of transfer. Once again, I'm a Volta River Authority. I'm a in I'm a defense. I'm a file like no. Now, can't send me a job. I'm a shikwe no na kashikwe jena I'm a me no podium chess and I won't chaff I'm a title of transfer. I'm a better title of transfer. So I wanna chaff. Once again, you see, majachame keke. Ni a follow proper procedure, and that is why we always find ourselves in this predicament. Shout outs to is it Coleman? In Naka, I'm set up as a land secretariat, and Shiko GF, all the schools should have a land secretariat. Basically, should have a land secretariat. Ni a properly trained person. Batana. Asere should have a land secretariat. Lantejan should have a land secretariat. Otublom should have a land secretariat. Abola should have a land secretariat. All these they should have land secretariats. Ni these are properly trained people. Ni I'm about running. Nekeni be no jugba. I follow proper procedures. The Land Act, I follow every single thing. Land Registry Act, I follow Lojogba. We cannot continue doing the same things. In the Einstein Charles Sekayeli, expecting I can no go back chake. When you continue to do the same thing, you continue to get the same result. Let's go on. In answer to paragraph 10 of the averments contained in plaintiff's claim, first defendant state that illegally acquired the said parcel of land from the Abola Piam family, the true owners of the land, and registered same in line with the Land Registry Act, Act 122 or there no channel or thereabout. And you find it ball is scan a cat in the First defendant says that it has lawful claim to the land and even over 27 years acquisition and possession of the land without let or hindrance. Plaintiffs are statute barring from initiating this action. Over how many years have been? Over 27 years. No statute of limitation. Ni Asere me challenge here. Nakaino eho. First defendant states in answer to paragraph 11 of the plaintiff's averment that the statutory declaration of the second defendant is neither a self-serving document nor secret document, but a document duly executed and registered in accordance to the Land Registry Act 1962, Act 122. Akekeji Asere me kakashi neke registration ni Abola Piam afe amefe ketoe nakano je anukwale ni because Land Registry Act ejino go ne yemlami. So mokonye eba register noko tumoboni law ke ni oba kake nakemo a register nakano nekete ni moko akana court Land Registry oba na yejeme no court Land Registry no oba na yejeme onyo kake mo a register ni nekete ne small moko ana. First defendant denies paragraph 12 of the plaintiff's averment and states that the defendant is laying claim to what it has legally acquired. Okay, once again, noni ame a chuni shikon na ameka ama no ame Water River Authority ame shikon na ame ele ye jalena keje Abola Piam biye ade. Paragraph 13, 14, 15, 16, 18, and 19 of the plaintiff's claim are denied, and plaintiffs would be put to strict proof. Once again, all these listed paragraphs say I'm in deny fe ni ame ba blami ojogbam. First defendant denies paragraph 20 of the plaintiff's claim and states that illegally acquired the land in dispute from the second defendant who had in turn legally acquired same, registered it under the Lands Registry. First defendant Niji Water River Authority. I'm again abi noni Asere me we ye paragraph 20 amega chuni eja ke shikon amele ye jalena keje Abola Piam biade ni ame register ye anukwale mi. In further answers to the plaintiff's averment in paragraphs 20, defendant states that granting but not accepting that the second defendant title is defective, defendant relies on the doctrine of innocent purchaser for value without notice. No, Water River Authority ke na keje no ni Josh bi epo you ake na kan ake register money Abola Piam bi a register shipon am register ya anukwale mi na wo je wa e ko wa eko ejake no go ye na chole innocent purchaser, the doctrine of innocent purchaser ni wo no nakano e cover wo ye mlami e cover ye wo mlami. So amenye amekeno afiwo. Paragraph 22 is denied, save as in hearing before expressly admitted defendant denies each and every allegation of fact as if same were set out in extenso and denied seriatim. The defendants first and second deny the plaintiff's claim, and in the amended statements of defense and counterclaim, the second defendant averred as follows: save as hearing after expressly admitted, the second defendant denies every allegation of fact contained in the statement of claim as if same were set out in extenso and denied seriatim. Second defendant admits paragraph 1 and 3 of the statement of claim. Paragraph 4 is denied. So na nibi any Josh be a avefe what ni ya ade eke no na me you fe ame male ebemi ame male ebemi ame male ebemi ame male ebemi. In further denial of paragraph 4, the second defendant says that the scheduled attachment to the writ of summons and statement of claim makes the land unrecognizable. There is need for a site plan to reflect the coordinates ordinated in the schedule. Once again, there was something in Josh be a winning Kanyabake. Abola Piam be ameke site plan ba ni aba na any potena me you ye adina ye be no watch ya de ke no na me chon no na me lencha me ye lencha anya recognize so I watch afon. In further denial of paragraphs 4.2, defendants say the land in dispute is part of his ancestral family. That is Abola Piam. Wachani ayade ke neke shipon ne Sowutuom shipon jine almost 7,000 acres ni aywe neke sanene ni le echema shiponi. Second defendant denies paragraph 5 and says the plaintiff could have allowed their ownership of any land in Ghana, but that exclude the disputed land, as the disputed land is part of Abola Piam families, granted to the first defendant by the second defendant families. Eke Joshi bi ambanya me kake shikonji ni yo Ghana fe amame no shineke shikonji ni yo Sowutuom mele no kometo amejie no yemi. Ambanya me kake shikonji ni yo Ghana fe amame no Sowutuom shikonji ni le amejie ame yemi mi yayade mi nchema no. Number 7. In further response to paragraph 5, second defendant says that plaintiff may have uninterrupted possession of any land in Ghana, but they have never had uninterrupted possession of the land in dispute. Okay, to obey Josh be a guy me Sowutuom ma oni mokuba me na egana ke amemanya me shikonji ni yo Ghana fa me nje me ni mokuba me na ni mokomogo bia me sade shikon ne na you ole mi ayade mi ma bia me sade nke shikon ne mi nchema no. The land in dispute is part of Abola Piam lands, over which Abola Piam have exercised control and possession from the time of settlement. The Abola Piam family on Sowutuom lands when they migrated from Ayawaso between 1680 to 1700. So what I need ayadeke nekambola neke shipon ne your Sowutuom ne you almost 7,000 acres now I play this particular case name here. What me? Bena jaya was okeba between 1680 to 1700 there. What na kan shipon ni wa shipon ya unka. Second defendant denies paragraph 6 and says that plaintiff cannot claim allodial ownership of ownership of any land in Ghana, but not over the disputed land. What I once again, Josh be and my make kake shikonji ni yo Ghana fe amame no she neke 7,000 acres ne almost 7,000 acres ne ni wo you are Sowutuom me no come to ele ameje amejomo ye no. Paragraph 7 is denied. In further denial of paragraph 7, second defendant states that the land dispute has been part of Sowutuom lands and remains so till today. What I need yayadeke neke shipone na apelio ye Abola Piam no Sowutuom efita shikonji na achole Sowutuom shikonji ye wala no rinka bake ko na ni nyotinto and other people I mean tana me jo man joy Sowutuom ye kana be lakabo etuma men ke bake be ko oshegamaji ko shegamashi kwamo yi na chono na Joshi ko Joshi no o sha anunsa no o she frimpon we agbon again no odo no lantenyan we no otublo no Abola echela no nakai. So ke what you think talk about awe o man George Sowutuom e take about dabi Joshi be asenemi alo Joshi fita agamashi anunsa fita agamashi agbon fita agamashi naketa agbon dabi je agbon be mi agbon sani ayu o je agamashi agbon ele solo agbon ye agamashi mi o man George Sowutuom. It is part of what is known as the Sowutuom lands. Kani moko lakabo na try na about creating like a distinction there now about feeling again about dabi. Don't allow that. Let's go on. Okay, in further denial of paragraph 7, second defense stand that the land dispute has been part of the Sowutuom and remains so to today. The said Ni Afutukote was installed only recently when plaintiffs started illegally selling off parts of the land granted to the first defendant's family of the second defendant. So what any ayadeke neke wache Ni Afutukote ne na US and here na magic bete ne no Joshi bi etole ni ame boy shikonji en homo ejeme shikonji en ni wo Abola Piam bi no ne sa na me ho na ma to neke wache Ni Afutukote ne yejeme ni shikonji na me ho shikonji ame mba no ni wake ha Volta River Authority ame mba mi. The presence of any subject of the Asere stool on any part of Sowutuom lands does not validate any claim to land by the Asere stool. Agana, me general Asere me call keji ame webi ye shipon no etwa ake shipon ama menoni. When Abola Piam family heard that Asere stool was going to install a chief at Sowutuom, they petitioned the Traditional Council by a petition filed on 12 March 2004. You see, look, I love doing this. Ona, enemy coming candy ehan kasio nimpi. Look, I am new to this thing. I've only been doing this for the past 2 years. And no any isumo cases ne kanemo ehan nin kasio ni. So I mean Abola Piam bi e ka na Joshi bi na me ba to ni afutu kote ni di kenklen what 2004 ton what ni wa file complain ye traditional council on aga wole ne but for neke judgment ni wa kan yone on aga wole. That is why I love this ke o taoni o kasega stories ojogba nke neke court documents ne they are gems ebano learning ebano so kana ni mba ni kan ye don't get bored. Natri ona ke fe nke sasanso bibio kome lakale ona koni entertain bofio bait oba na ni bia mi ojugba no oba na ke nu meni metalaje amalelo so man dwalo ni fitelo man dwalo so Abola Piam bi again na menu akene ka futu ko te na ya tole in 2004 I'm a face specific 12 March 2004 amete ni ama file no ko traditional council again na ameba mento Joshi bi eba eto manche ya wa shikpon no on 12 March 2004 and replied to the petition filed on 26th April 2004 and signed by the plaintiff hearing. The plaintiff stated clearly that they, as the family, so Abola Piam bi signed petition 12 March 2004. There was a reply from Joshi bi on 26th April 2004. Signed by the plaintiff ni be wache ni afutu kote ne ni le eyomi ne le a sign I can reply ni akeba. A senior elder of the Nikolai family of Asere Joshi do not appoint chiefs and had nothing to do with the installation of that chief. Oh, I can reply now akeba. Yeah, plaintiff ni oje kagena you see Nikolai we kuichwe ka to manche ya sene ebe no go frame yemi no manche na so ko ya to Sowutuom melele ko am reply ni Joshi bi amekeba yi onukpa ni yomi no na ekeba ne. In reaction to paragraph 8, second defendant says that plaintiffs might have collected any compensation on any land, but not on or in relation to Sowutuom lands. Agana, kaji ameka me compensation jikome, amanya me compensation shikmo jinkome. Shineke Sowutuom shikmo jine sandedi wo yuone no ele no bemi nkokoko. In response to paragraph 9, second defendant states that some persons of Asere origin have illegally sold some parts of Sowutuom lands to unsuspecting lessees. Wachani ya de ke na yeah ame paragraph 9 na ame na ame ani wana wali aka ame Joshi bi ame o shikpo jiye kome ke ame kome ni me ame li ake shikpo je Joshi bi ano. But the said grantors have not been able to give title to the grantees. None of the said developers have obtained any document of title to the land. Now, it's quite interesting to get response name. Okay, earlier on any one kind of plaintiffs are very maintained Joshi bi I mean Tono Gwake they were talking about title. Biane wachani ya de la unkanta de kama ke ame unye kwa shikpoji na me kama masene ma me ho ya me ke ni bi efe na ke me hu ame nyeko na me ba register na ma na title ya shikpoji ano e ya ka me Joshi bi je ame no. In response to paragraph 10, second defendant asserts that the first defendants are lawful claimants to the land in dispute because they were granted the land in dispute by the accredited heads of family and elders of Abola Piam. I mean, Chono Wegedabi, Volta River Authority, Shikpo Amamenoni, because Abola Piam be home. Second defendant denies paragraph 11 and also denies that the defendants are relying on the secret document to claim titles to the land. Naked registration ni Abola Piam bi afair ama afair ye temo mi ame ani afair fan ni mo fe mo ba na watchani ya de ke ame ke wo afair no ko temo mi ame male no na ame you amele. Second defendants published a public notice on Abola Piam lands on the 24th January 1967 edition of the Daily Graphic. Oh, inga eneme kami kan ye ngonna chon ngonna e ani nkasioni. Come on again ama gamini ama make wa register shipon ye temo mini wo male ame male nye kwa 24th January 1967 Daily Graphic what new register shikpo wana publish ni Ghana be fe anake ne ke Sowutuom shikpo ni fe wa wononi ne wakeji Josh bi ke wo wakani fe temo mi wani mo kwara ni mo ko ba yue amle chamele no na me yuo ama Daily Graphic 1967 you know ame ba na ke wo wana fe fan wakano ko ete. The publication appeared on page 13 of the said edition. I'm a town, 1967, 24th January. Shipone. I go page 13. Come at page 13. If I found you get me, a man no friend, I get what? Mino was shipon, I no go work. What can me she find? Ni mofemo quick, mofemo na le fili gado, mofemo fili gadoji, alodena gago, mofemo na le fili gadoji. Need the for your concert in again. The Abola Piam family legitimately publicized its claim to Sowutuom lands in that notice, which lands are the ancestral lands of the people of Abola Piam. Neke notice ne were published. The said land is bounded on the north by River Insaki and Ofanko village, on the south by Kwashiman village, and Asere two lands on the east by Onamroko Adai family and Awule Mona family lands, and on the west by Ablekuma and Owuraman villages, all measuring approximately 6,698.726 acres. The Sowutuom lands are the ancestral lands of the people of Abola Piam. There is and has been nothing secret about the declaration of the Abola Piam lands as their family lands. So once again, I'm a trouble. Almost 7,000 acres. Sowutuom lands. I'm a menoni. Muko klanye kake. In further response to paragraph 1112, defendant says that the statutory declaration made by the second defendant's family in relation to the land was duly publicized. Once again, I mean repeat it. Ni wa register wakachon. Jele mi fe 24th January 1967 Daily Graphic called the 13th page ubana yejeme. The declaration was registered as number 1529/1969 and stamped as AC 2887/69 in the land registry. The document is and has been a public document. It is not a secret document. So we register we were fairly plain. So okay, Josh be a secret document in here. I'm a Mali. Second defendant says in reaction to paragraph 12 that plaintiffs recently got to know about the declaration because plaintiff and the stool have been under the mistaken belief that Sowutuom lands have no owners. It was when they were confronted with the identity of the rightful owner that they became aware of the position of the land. Okay, now Josh because all this while ya me feel like a Sowutuom me jemo kono nie ne wa me ke na me bata ni ame kwa ke anishiko na me kono lo bako dani bi ane ni akaba klame nya ke kwa shiko ni nye juoshi ni nye ho je nye no nie bako ne wo ne ame na ne ke register ne shi ame fe kono ko ketiko. In further reaction to paragraph 12, second defendant admits that his ancestral family lands in Sowutuom share a common boundary with Asere lands on the southern part of the land. But that is all. Okay, now, what do you want? Was Abola Piam wekue? Yes. Waka sene se, waka me ya unsu. Ye waka me ja unsu. Ye neke kokpano. No pe unsu ke pe waka me ja. She neke shikpo ne na ayu osanene. Ame no be me. The Asere stool cannot and will not be permitted to surreptitiously or over alter the known boundaries between the second defendant's family land and Asere's two lands. Again, Asere menye teshi. Nika usu ni waka amete ke jobu ade amede enchame ba chake na kan usu wakpe na ame kokoko. In response to paragraph 13, second defendant denies that the statutory declaration and the reference in South 7, the land at all matter of times been part of Abola Piam lands. Let's go on. Paragraph 14 is denied and plaintiff will be put to strict proof. Paragraph 15 is denied. Sowutuom has never been a settlement of Nikolai's stool of Asere. The Asere stool has never taken possession of any part of Sowutuom. If they ever did so, it was illegal. Watch it, ni ya de ke na Sowutuom shikpon di asene mano kejo boade. Ame oni ko neke shikpon neda. Ni keji be ko eba. Ni ame ko eko neke shikpon ni ame ko yegbe phone me. Na kaino esa na ke tuoni. In further reaction to paragraph 15, second defendant says that the plaintiff and his elders have not been properly briefed about relationship between Asere Josh's 2 lands and Sowutuom lands. Wachani ya deke wanyema seneme Josh bi na mekeneke sanene ba efe mi ake agba me shile ni amecheme ke wocheme inshi ne wona amefio no ne amefio. Available correspondence clearly indicates that in recognition of Sowutuom lands by the Asere stool as Abola Piam, the secretary to the Nuclear stool family of Asere Josh, in a letter dated 10th January 1965, invited Abola Piam for a meeting on Mukose lands. Akena, me, iya wolo ko ebi e. Ni ame Josh bi e, ame secretary koma. 10th January 1965, ni waba, ni Abola Piam bi waka ma abatashi, ni aywe Mukose shikonjiai. Abola Piam replied to the request in a letter dated 10th January 1966, signed by the secretary of the Abola Piam family. Ni neke wolone ni ame secretary Josh bi ame secretary ma wo Abola Piam bi wa reply na kan letter 13th January 1966. One was secretary my letter they can send you. You see how beautiful the history is being told. How beautiful the history is being told. The Nikoff Life family again wrote to Abola Piam about the same Mukose lands on 11th May 1966. In short, correspondence will be tendered to support the claim to all Sowutuom lands, including the land in dispute by the Abola Piam through the defendant. Akena, me. Watch I need ayadi. Me. Neka wojine fen ye. Inke fe baba. Ni ke amele. Amena ni bi ni wa cheme ka me cheme ba. Ye neke shikpo jinai. In further reaction to paragraph 15 and second defendant, defendant will prove this by all available oral and documentary evidence. I can look. No need deny me. Me don't matashi. Ni magbasanie. Ni gbasanie keke. She was jinin yo. Nink ba pia in money ma UFA say in cafe bahanye. Second defendant denies paragraph 16 and says that Abola Piam as ancestral house, a settlement popularly called Atipo Kope, named after one of the caretakers of the ancestral lands. Be ona BNN weko ona ke Atipo caretaker ebile benye na Atipo ejebo ebi eko. So Abola Piam bi eke amega wo yi go jameda wo in jama ahun ake woke shikpon eko hamuku ni ekwano enwo woke egbe ewo na kanjame acho jame Atipo Kope na kan Atipo wo woke shikpon ale. Evidence will be led to show that every year the Abola Piam goes to sprinkle pepoi on the land. Evidence will be produced to support this. So once again Abola Piam bi eke wo da fear wo ya Sowutuom wa ashwani mene ameto manchefio ye Sowutuom shikpon jinya kono no ne ashwani ya chosani woche yi ya de ke jo buade ama Abola Piam bi ama me shwani ye Sowutuom ke jo buade ni ame ba jie wo jinke chon aka ama me shwani ye Sowutuom. The following documents would, among others, be tendered in support of the case of the second defendant, namely, indenture showing allocation of part of Abola Piam lands to the Catholic Diocese of Cape Coast for a Catholic seminary. Excuse me, me picking those. Shikona Catholic Diocese of Cape Coast now make a seminary. Abola Piam bi amameke series of letters on compensation payment to Abola Piam from 1953 to 1953 through the Franco Manche. Ake ame compensation baba ni ame ke 53 ke bata 56 na ke chon franco. Look, Abola Piam, you need to get your freaking house in order. Respectfully, Cheme Kenyeme, get your house in order. Fix this mess. You need to fix it. Fix your house. Mofe money eba shika ni eba go against the nekenye no kone nye excommunicatale nye tiashi. And when it all goes well, you are young. You need to work for the best interest of Abola Piam. If everything gets settled, you know, fair no teno jogba. Make sure you work for the look. Boji manchewulu, but make sure. I'm speaking to you directly. I'm looking through the camera and I'm speaking to you directly. Make sure, okay, you will be the difference maker in Abola Piam. Be that difference maker. Don't follow the same way. Ne put Abola Piam in this predicament. Abola Piam yone. Like I said, but you can do it. You can change the fortunes of Abola Piam. And I'm sure there are people there who will help you. Look at all these people. They are putting their lives on the line for you. Do not disappoint them. Do not disappoint them. All these they are putting their lives on the line for you. Do not disappoint them. Build Abola Piam family back. A judgment of the Supreme Court dated 28 January, July 1987 on Mukose lands. Composite plan on claimants for compensation on land compulsorily acquired for the police depot and training college. Composite plan. Ni wo Abola Piam be wo ka shikpo ko ha police depot for a training college wo composite plan en baba. Letter on release of 1/3 of land compulsorily acquired for the police depot and training college back to Abola Piam family. Ni inka wo lo mba fitai ni e ba prove ake ne ke police college ne shikpo wo ka ha compensation claim by Abola Piam family for land acquired for Olympic complex dated 2nd April 2003. Inka wolo umba achon ni wo. I pay wo compensation for Olympic complex in 2003. No compensation claim by Abola Piam family for land acquired for police depot and training college also dated 2nd April 2003. Once again, neke police college ne no apay wo nke no baba. 7 sheet number 0501B3 showing towns, villages, and settlements sharing boundary with Sowutuom lands. Towns legislative instrument number 1565 of 1993 on lands title declaration of Accra District 07. Number 1565 deed of variation on Asafo land showing boundary with Abola Piam family land registered at Lands Commission on an LVB dated 14th June 2000. What I need again, not produce a name. Statutory declaration by Alfred Kolai Boche of Awule family of Accra showing boundary with Abola Piam lands. Onake plaintiff any Josh be I'm a Awule wekuko watchani ayade me inka wolu baba ni obana any Awule be any work I'm sure unsuye obana indenture showing deed of gift by Abola Piam to Asere Omang family of Abola Piam dated 20th October 1964. Ubana as far back as 1964 did ko ni wo kemoko shikmen ko nke no baba no na composite plan prepared by Lands Commission dated 6th month 2001 showing conflicting claims to lands in the Sowutuom lands dated 6th June 2001. Work another composite plan baba the Lands Commission denche fe in 2001 ubana. Letter from Land Valuation Board dated 6th May 1999 add to claimants for land acquired for the Olympic complex in claim of Abola Piam. Affidavit in opposition in suit number BL 479/2005 deposed Festus Nikwe, that is Reverend Joshua Kwame in Tim Jakari versus Festus Nikwe 2 Margaret Efford. The defendant denies that plaintiff owned the land described in paragraph 19. So once again, second case said no nakano. You see a whole lot of stuff there. Let's see. Particulars of fraud. I'm a respondee. Lifting in all the coordinates and schedule of the Abola Piam ancestral lands published and registered are reflected in paragraph 14 and 15 of the statement of defense and presented the said land as Asere 2 lands, failing to show evidence of registration of the land described in paragraph 18 or showing their root of title by falsely declaring a court process that the land so described is Asere 2 lands. I'm counter enemy. Second defendant denies that any fraud has been perpetuated and by his family and the particulars of fraud and allegations stated in paragraph 19. Second defendant challenges the plaintiffs to provide copies of the judgment mentioned under the particulars of fraud and illegality. Second defendant will put plaintiffs to street. So, neke fraud. Ni Josh be a UFA Abola Piam be through Wachenina Yayade. I may deny that can be a fan. Josh be a Josh be a prove. I'm a Benoko Kwana and I may prove. Paragraph 20 is also denied. Second defendant asserts that plaintiffs are not entitled to any of their claims or at all. What I need I had nibi the new UNFN do try Josh be I'm a Benoko Kula, nibi and I may be a fan. Agahame. Counterclaim. Second defendant repeats paragraph 1 to 30 of his statement of defense. Once again, I got repeating declaring, confirming that second defendant family, the Abola Piam family to all that parcel and piece in Canadian Habu. And order declaring that so NBNFN can it repeated the same thing as their counter claims. So let's go on. Okay, now what can you on 28 February 2006, the plaintiff in suit number B also once again Consolidated issued an amended writ of summons and accompanying statement of claim, which is one of the consolidated suits against the defendants, of Visitation Ministries and Dr. Isaac Abebio for the following relief. So once again, I got another case go eba fita. Iban give like 3 cases ni afefe ekomie. Recovery of the land in dispute. Perpetual injunction restraining the defendants, his agents, workmen, assigns, etc. from entering the land in dispute and having anything to do with the said land. General damages for trespass. Declaration that the disputed land forms part and parcel of the Mukase lands and owned by Nikolai Stool of Asere. The plaintiff averred as follows: it's amended statement of claim. So this second one there, because a corner can no is pretty much a repetition of the same thing. In Kandi Ameabu Yama Vermin said earlier, they are making the same case. Now was keeper because documents say what shaying. Oh no. Once again, come on, the same thing. The defendants have unlawfully entered the land in dispute with the intention to construct buildings on it. The plaintiff says that entering of the land in dispute by the defendant without authority of the plaintiff amounts to trespass. The plaintiff says that defendants have been warned several times to enter the land in dispute, not to enter the land in dispute, but despite the warning, defendants continue with their acts of trespass. All that piece or parcel of land situated, lying, and being at Sowutuom, bounded by the north by a proposed road and measuring 830 feet So this particular case is the same thing. Once again, bear in mind, it's 3 cases. Now failure kome. Shike okwe is the same repetition. The averments trespass, fraudulent, illegal, all the same averments belongs to our stool. It is not their family land. They are trespassing. They've sold some illegally. They've acquired compensations illegally. It's the same averments. The same, because I talk about 7,000 acres. So so the same averments is being repeated. Nyani what ya here? What make progress? Oh no. Defense to counterclaim. Defense say I'm a counterclaim. Save us once again. The same counterclaim. Now make about come on. In further answer to paragraph 6 of the statement of defense, the plaintiff says that Abola Piam to my family of Accra are not the Alodia owners. On again and Abu earlier. So let's make progress. Let's make progress. Now I make our progress. Now I make our progress. The same thing. The defendant's land is situated lying and being at Sowutuom residential estate layout, Accra Northwest Sector 3, and bounded on the north by proposed road measuring 830 feet, more or less on the south by proposed road and measuring 860 feet, more or less is the same thing. So now we make our progress. Now what can I no go be catching eye? Defendants say that soon after the purchase of the land, they took possession by putting various caretakers on the land to clear and farm the land and have been in effective possession since date of purchase. Defendants say that after purchase, they entered into arrangements with the Electricity Corporation of Ghana to extend power supply to the land in preparation for development projects on the land. Defendants further aver that after all necessary estimate of the cost of extending power to the site, the Electricity Company of Ghana wrote to defendants to pay an amount of 15,946,000 cedis for the work to be carried out. Defendant duly paid said amount and power was accordingly extended to the site. So Abola Piam be a kaka ne kashikpo ne ko na ameke ha ni me na me UF ama pay ECGB ni ameke light ba wo jeme fe kenibi je asene je Josh men ya pay wo Abola Piam be wo pay na ke light ba wo jeme fe ka ba me shikpo ne me no na me ya pay ECG na ke light ba wo jeme. In denying plaintiff title to the land, defendants further aver that the root of defendant's title is a statutory declaration dated 24th March 1969 by one Ni Amponsa Ankra, deceased, and registered as 15/29/1963 at the land registry. Defendants say that they have since the time of purchase carried development projects such as buildings on the land and have alienated portions to sister religious bodies who are in the process of developing the land. Defendants consolidated their possession of the land by planting following trees, among others: mango, cashew, lemon, orange, and salsa. Defendants ordered a layout of the whole land to be prepared and was done, delineating the land into appropriate segments and portions. Defendants built a house on the land for residential purposes, classroom block, and a nursery, and an uncompleted building all for school. Defendants put a caretaker on the land and granted him a portion on the land for farming purposes. At this time, defendants have resisted activities of trespassers various times, including court proceedings. Defendants say that if even the land belongs to plaintiff, which they deny, then the plaintiffs are statute barred from bringing instant action, which must therefore be dismissed. Defendants say that if even the land belongs to plaintiffs herein, is denied, then defendants will rely on the doctrine of laches acquiescence. I think I can do particulars of acquiescence. Plaintiffs are fully aware of the claim of the Abola Piam to my family as contained in the statutory declaration of 24th March 1969 and registered as number 1529/1969, but not having done anything about it whatsoever, and the said declaration of the said legal document. Plaintiffs stood by and watched defendants arrange for and expend the huge sum of 15,649,000 Ghana cedis to connect power to the site for as far back as 1994 without any challenge whatsoever. The extension of power has consequently enhanced the economic value of the land very greatly since plaintiffs have stood by and watched as defendants successfully resisted attempts by various trespassers on the land since 1979 to date. Save as hearing before expressly admitted, defendants deny each and every material allegation of fact contained in the amendment statement of claim as if same were denied in extenso and traversed seriatim. Defendants say therefore that plaintiffs are not entitled to the claim or at all. Counterclaim. Defendants are make a counterclaim. No unko nyake me dan nko nye ke ofe ready ake oba fe nege liga be prepared because there will be a counterclaim. Be prepared. There will be no, so you better make sure you have money because abaye shamunkulu boy odi. O shamunkulu abaye odi. So you better be ready for counterclaims. Be ready. Defendants repeat all averments and in the amendment statement of defense, particularly paragraph 7 to 18, and counterclaim as follows. Declaration of title to all that piece of land subscribed in paragraph 10 above. Recovery of possession. Perpetual injunction restraining plaintiffs, their agents, assigned servants, successors entitled from laying any claim whatsoever to the land, to the said piece of land. Damages for trespass, cost, any others, as this honorable court may deem fit. At the close of pleadings, the following issues were set down for determination. Now, agbene judge eke imbomofe motwe agbene ni imbomofe mogwe wakpene ake sande ni waba ye none. Number one, whether or not the plaintiff is the owner of the land in dispute and its surrounding areas. Judge eke sande komeni waba ye ji ake ani waba kwa ke lele ake Joshi bi ene ke shikpo ne ama ameno nilo je shikpo pe she shikpo ji ni fita neke shikpo ji ne na apeli oye NFA and Joshi bi elele ameno nilo. Whether or not defendants are the owners of the land in dispute. Waba kwa ke ani Abola Piam imbiye ame o shikpo ama ameno nilo alo Joshi bi ano waba kwa no. Number 3, whether or not the court judgments mentioned in the plaintiff statement of claim and the defense of the counterclaim affect the land in dispute. Nyebana ke Joshi bi eche cases come pinaye. Je ke wakpene aka obakwe aka nege cases na meche aka ye ani eko shikpon ne ni wo yosane eko neke shikpon ne ekolo wobakwe ni wakwa aka eko shikpon neke cases ni Joshi bi eche ofin aka nono amedumo na amekwa aka Sowutuom shikpon ya ame no wobakwa aka neke cases ne eko shikpon ni wo yosane ne elo. Whether or not the court judgments mentioned by the plaintiff in the statement of claim and the reply and defense to the counterclaim renders the deed of conveyance registered as 225 as null and void. No once again neke judgments ne friend na meche waba kwake ani ke eyemiye be noni Abola Piam bi ama register ke ni bi fe ani na ke no if you all null and void lo. On 25th October 2011, ajeshishi agbena abo insane shishi agbene nyebu atwe. So no ni nkan ye fe shishi je bago jeje babo temi. Nibi ni mo fe mo keba no jeje no nkan fe aboe no na keba jeje e ga party mene yue okay nye fe nye kesane ba mini pote nye ba sumo ni what decide no am fa me ba together ake oba decide neke no ju no ni nkan abo eli agbene abajenshi. On 25th October 2011, recently, Festus Nikwe gave evidence on behalf of plaintiff, the appointed regent caretaker of the Asere stool. So 25th October 2011, what actually Festus Nikwe le eba yoda se Asere se he had the knuckle of attorney which he tendered as exhibit without objection. Exhibit A without objection. Objective. He stated he knows the second plaintiff who is the acting head of the Nikolai stool of Asere, Monifite inake sanye ba ekelele. Elemo ake leji wekuicho ye Nikolai. He said that he knows all the parties in the case with the except of Ni Oma Minsa Family Limited when they all trespass on various parts of the Nikolai stool of Asere land referred to as the Mukose land covering an area of over 15,000 acres. Company na chole ni Oma Minsa Family Limited. Amepe jimeni amele. Ejage nekegbe mene ame trespass ya sene ma shipono ni achole Mukose land se Mukose shiponji ne cover about 15,000 acres. He stated that the part Mukose land the defendants have trespassed on is located at Sowutuom and its environs. Walewe kake neke shikpo ne li Abola Piam bi ne kemena me ho shikpo jine ha ame bami na ke no achole Sowutuom shikpo jine ni eba describe any account bounded on the north by Asere stool land, on the west by river in Saki, on the southwest by Mukose lands, and on the east by Onamrako Adai family land and Ankra family land, and Asere stool land, an area of over 60,000 acres. So I mean kagena nekejeme be fe ni watch fe asene ma no fe asene waka fit here when you over 60,000 acres. So watch a Festus Nikwe odasene yone nya watch. He stated that the Nikolai stool family of Asere became owners of the lands by settlement when they migrated from Ayawaso to the coast. To the coast. Knowledge of the Abola Piam family, I guess. Okay. Nege Nikolai wokune wo. Biami ni waje akos Ayawaso womba ni womba nshona agbe wo ni wabato neke Sowutuom shikponji ne na yuo ni Abola Piam woku ameli ake wo bato jeme. After settlement, the Nikolai stool family had been in possession uninterrupted and subsequently litigated with other people and have had various judgments which shows they have litigated with other people and have won. I can do about Tojeme. Even Abola Piam be a liake wo about Tojeme. Ni wakeme pi Sunday. Yeshiko jine ni yo jeme fe ni wa yekunim. Ni Abola Piam be wa me liake wakeme Sunday. Ni wa yekunim ya neke shiko jine ni wa yuoi. He stated that they have various judgments which show that the litigated with other people and have won. They litigated, excuse me, Bolly, Ekati once again. They litigated with other people and have won. That they have the privy judgment, with the judgment which was between Willie Nikwe and Ni Amasa Nikolai versus James Adams. Akena blema. Ba yele sanje ke ya get the privy council ye London ye London. I mean again judgment here. Ni ne case ne ame nyemi ko na achole Willie Nikwe ke ame che ko na achole ni Amasa Nikolai niji enumu. Nikolai ameke mo go na achole James Adams ye ne ke sanene. He also tendered Exhibit C, a judgment from the Privy Council dated 1961. Once again, it can exhibit teba. Ni chuagelele ayeneke sanene in 1961. Ni amewini. Exhibit D, E, and F were tendered as judgments. Exhibit G and H were tendered with Exhibit H being a public notice of 1967 on Mukose lands. So I may tender exhibits ni I make a public notice ni amo make a wo 1967 ye Mukose shipon I make a wo mami ni jeje enake no ne yuo lewu eyewolo ye. He stated that if the Abola Piam family says that they migrated and settled on the disputed land, then there should be no need for them to make a statutory declaration which was not published. Okay? Hey, now what published in 1967 ya ke shikpo jine fe wo no mi. Can you lele na Abola Piam bi e amegena aja ayiwa so yi aba amefita wo ba enya ni ameba register shikpo ni ka ma register shikpo amekeba to na me ha ni mokwale wo no wo keto. Mind you, Abola Piam be I deny. We'll get there. And that if the Nikolai stool family does not want the Mukose land, including the disputed land, they would not have taken the trouble writing to the Abola Piam family, inviting them to a meeting. Since the land is not for Abola Piam, they cannot grant same to the Volta River Authority, for the land forms part of the Mukose land. Keji Abola Piam, keji ame Nikolai wekue, ame ke nike shipone, ame sumo alo eko ame yekue, ame ba ame na ni ame bagma wolo ke Abola Piam wekue ni abatashi na yue nike shipon jine sani. Ba akeni eko ame eko ni ame liake shipon ame no ni ame sumo ewo no ewo ni ame Abola Piam biye boni afe ni ame tashi akenyeme ni ayue no anu ewo Abola Piam biye ame beigbe ni ame ke shipon jine chomoko ofine abi gonti no ni ya anweko jani femo kiamoko ni okiamoko abo isani emi agbena abotemi mo femo ebe ewe jeje mbotue nyawa ya. Under cross examination ni chwake ni a lawyer lead into evidence ata Abola Piam be a lawyer all Volta River lewe baba ne ba ball cross examination. The witness stated that they had not registered the land. And the reason was that those days, anytime somebody trespasses, because everybody knows that Mukose land belonged to the Nikolai Stu family. But if you dare attempt and you trespass it, we take you to court. And that mandates us to show that the total Mukose land belongs to the Nikolai Stu family. And if they get to know that somebody has trespassed on the land, they take the person to court. So, but onage lawyer be like kidi oke ne ke shikpo ji na efe yenye no mie mi no ne register ko e ke no no we register ko shikpo ji ake joshi onupa e komi ayu o yi ake na ken bi ami mo fe mo li ake mu ko se shikpo ji yen joshi bi ano le wo ke mo ko epele ni anytime ni mo ko ba fe yi ake e ba bote mi yen wo ke mo ya court ni ke wo ke mo te court e wa chon ni wo yodase ni mo fe mo na ake lele shikpo wo no ni wo kabata bia ne wo register ko na kan shikpo ji. He also stated that Exhibit E, which was tendered as showing Nikolai's tool of Asere land of about 15,200 acres, the land was not registered, and it bears the date 14 June 1960. Actually wake esake exhibit ko ba ni chonake neke Nikolai shikpo ji ne fe it's about 15,200 acres. Shimon neke shipone a register ko even though wolu ene ke ba date ye no ni date 14th June 1960. The first plaintiff under cross examination admitted that the people mentioned along the boundaries of Sowutuom, Awulemona, Ofanko, Kwashiman, and others are all people who still have their boundaries with the Abola Piam Sowutuom lands. Nichwanke na sa abile sanie yanukwale ake he admitted nichwanke engono ake leleng me kome yani ameke Sowutuom shikpo jine shore boundaries awule mona ofanko kwashiman ke ene me fe ameke me kome shore boundaries ni na kan boundary na ameke mon shore na kan jeme wobanye woka ake Abola Piam bi ashikpon ni. He also stated that he was not familiar with a letter dated 10th January 1965 inviting Abola Piam to a meeting on Mukose lands. Naken letter ni wache ni yaya deke amecheme ngma akaba fe meet ye Mukose lands ni abile sanie ekele eliake naken letter ko ye. He was also not familiar with the situation where the secretary of Abola Piam wrote to Asere Joshi about Mukose lands. Naken letter na ngma ko ba kan ye bia me ni yayade a response by kake I'm responding and my letter sometime March ni am responding jo April am responding wachane na abile sane e ga liake am cheme exchange letters ko me tumona kan. The plaintiff's representative showed lack of knowledge about the Ghana Olympic Complex land, which was acquired by the government, as well as the acquisition of the police depot land by the government in 1975. Neke wache Felix ni kwene ni abile sanie eleno kokula ake government of Ghana acquire shipon for Olympic complex. In the government of Ghana, no, acquire Shikon for police depot. Yeah, 1975. He also had no knowledge about the compensation that were paid to the owners of the land, which did not include the Nicolais too. Neke Shikojine na for Olympic complex police depot a pay compensation ko klapo ken Abola Piam elepo klapo. He indicated under cross-examination that he was not aware that the government released 1/3 of the police depot acquisition back to the Abola Piam family. No wale ele klapo ke ni government boli after a while boli kume abagma ake na agme ya woyi. Ele klapo ke government release 1/3 of Shikone acquired in 1975 police depot. Eliaka government release 1/3 ke Abola Piam family. On the VRA land, it was said to have been acquired in 1979, but the plaintiff said they were not aware, and anytime they become aware, they go to court. Once again, Volta River Authority, I'm only Abola Piam be a Kashipon arm in 1979, watch a Felix Nikwe, ni Edomo Joshi be Anajia, a gala wele. Akabola Piam be a make a shipone a Volta River Authority, yeah, 1979 ton. Because anytime now me bana akamukwe kwa me shipon ame ya kotu. He was also not aware of the Olympic complex acquisition of 1975 and has not seen the executive instrument. Eleu aka government acquire ne ke shipon no from Abola Piam in day. 1975 ton ni no under an executive instrument. I use executive instrument ni akeko na kan shipon. Under cross-examination by the first defendants counsel, baby and the first defendant, the Volta River Authority. I'm a first defendant. Ni I'm a lawyer. Watch ni kwene sanie. The first plaintiff stated that they are very vigilant when it comes to the issue of trespassing on their land. And anytime there was a trespasser on their land, they got to know, and they go to court. Okay, I'm a Joshi be. I mean, here come a Shikonjiano. Why? Ni any time, ni moko ba trespass, moko ba jewan ne ba no. I make a more ya court. He said he didn't know that the first defendant is an effective occupation of the land, but they heard the VRA is within the area, but there is nothing there that shows that VRA is within the area on their land. Okay, Elia Volta River Authority ne ke Shikone. Ameyanopo, amenumo ake VRA. Shameliake VRA. Fenoko ya ameshikpono. He further stated that they realized that VRA was on their land immediately. VRA demolished things on the land, and this came to their notice just before the institution of the writ. Okay, ameyosemo no ake Volta River Authority ba ameshikpono. No, ake Volta River Authority kumonibi yagame ni nohani. Also, he stated that none of the 15,000 plus acres of land has been duly registered. But as soon as they found anybody on the land, they went to court and had judgment. A repeat on a I mean, 15,000 acres in it. I'm a register code. Share the time. Nimo baba, nimo bafe to me baba no. I make a more ya court to. I may hate shipon. Under cross-examination by counsel for the third defendant, the plaintiff third defendant, Ni Oman Family Limited. Under cross-examination by counsel for the third defendant, the plaintiff told the court that it is 6,220 something acres of land that is asking the court to grant them. He knows Ni Oman means some family, and that they are a branch of the Tumagwe family. So once again, under cross-examination, plaintiff admit that yes, ele ni ominsa ni oma minsa wekune ni shiponi kaka ke is 6,220 something acres. The first plaintiff's representative under cross-examination said that he was not aware of the Gazette published in 1961 and 65 that schools, families, and individual lands in the Greater Accra region must declare those lands to the Lands Commission. In 1961, 1965, ake shikpo jimfe ni yo senko shishi. Alo ye wokuko shishi. Alo mokono neke shikpo nefe esani a register with the Lands Commission. He also stated that it is through this case that they got to know that Abola Piam has given land to others within the 6,000 acres. Eka me upwe amelepo ake Abola Piam imbiye ameka shikpon ame kome. Je sanene na ke bakotu ni ayone nkwe amele ake Abola Piam ke shikpon me kome. Nyawa chano. During the cross-examination of the plaintiff's representative by counsel for hour of visitation, once again, hour of visitation, I'm near Kwame, Dr. Nokwa Baby and now. He stated that he got to know that the hour of visitation ministries was granted the land as far back as 1979. Once again, Josh Inue, ne eta nienu egale elekula ake Abola Piam imbiye keshikone eha neke somone 1979 ton elekula ake Abola Piam imbiye keshikone eha 1979 ton. And there is also electricity supplied to the land occupied by the hour of visitation ministry. Ne lepo ake light po e bashikon ni neke hour of visitation ministries ne amameke light e bashikon le Josh Inue egale lepo aka shikon ha 1979 ton le unpo aka amame agbla light keba. The first plaintiff's representative also stated that they have not in the last 10 years granted portions of the land to anybody. Ameke the last 10 years amameke shikon akomukum. The plaintiffs also stated that they are aware of the developments by the hour of visitation on the land, and they, the plaintiffs, have not granted the land in dispute to anybody. I mean, hour of visitation. I mean, develop. I mean, shipon shiame. I mean, Josh Bie ni ama me shipon ni. I mean, shipon na kan shipon akomukomukomukomuko. The plaintiffs' representative stated that they have also not registered any portion of the land with the Lands Commission or Land Title Registry. The plaintiff's representative also stated that he does not know that owners of lands must have their lands registered. Wachane dumo Josh Najia, ega me shikwanji ama me register ko eko. I register ko eko kula either Lands Commission jo eko ame register ko ni ame leake America me yeshipon esani ama register ke Lands Commission. Can you imagine? Can you imagine? Ega me leake ka me yeshipon esani ama register a Lands Commission. Oh my goodness. The second plaintiff did not give any evidence, and no reasons were offered as to why he did not give evidence. Again, monifita wacha komi ande fita Josh bi aye le ekenoko no kula ba ni egbla mi hu no ni ekenoko ba. The plaintiffs called Numo Tomonli Yate the second head of the Naiwe family who gave evidence. So I'm a chemoko. Josh be a chemoko. Kege Naiwe ni ebaye odase ehame. Midijino ni money Josh be a check kege Naiwe. Actually Numo Tomonli Yate Iliake Tomonli ni amengmalalo Tomonli. I don't know. You can correct me. Yate Shibona Angmalena can chole. Midijino ne he testified that he knows the Nikolai family. Egele Nikolai wekwele amewa. He came to know them when they gave their father some land within their Mukose land called Chantang. Obanake wakane nake elia in their vermin say. Yoda sagelele Nikolai wekwe ame nae wekune ame ni ame cheme ha ame nae wekwe shikon ye any atole Chantang. And that his grandfather, who was their family head, took the land for the grant of the land. Ni ame che le eni le numone eni jimoni ehe nike shipone. He stated that Sowutuom and Chantan are all within the Mukose land, which is for the Nikolai families too, and they share boundary with them. Eke neke shipone Sowutuom ke neke Chantane fe efita no na chole Mukose land there. Ni nakano wakame sure usu. That Chantan came to be known when the lands were given to their grandfathers. Ake shikon na chole Chantan ni ake ha wacheme ni abale na kan shikon. He stated that he knows the Abola Piam family very well as Tumawe people of God. Ni lewe le numwe eliake Abola Piam biye tuma webi jiame ni amejagami that it does not agree with them because when they were granted the land at Sowutuom, it was within the Nicolai's two family already. And if the Nicolai family agreed to give the land to them, then he has nothing to say. Newa ekatuma we bi ekpangbe, Abola Piam bi ekpangbe. Akena ken shipon amameno because na ken shipon ba ha me. Je Abola Piam we bi eni ken shipon ha me. She Nicolai wekue ame ni ame ken shipon ame. And a cross-examination by counsel for the third defendant, the witness said he got to know that Nicolai family had the land from Mukose, and they gave Chantang from it to the Naiwe family, and this was in 1896. Which a numo yate ke le keje eliake neke shipone Abola Piam dabi Asere Joshibi ano because I'm Asere Joshibi I'm make Chantang shipon ha amenaye wekune 1896 ton, but cannot tell if the whole of that area was named Mukose, and it does not understand the meaning of Mukose, and does not know the extent of Mukose lands. And what was given to them was a gift, but does not know the services and customs his father performed for the plaintiffs for which they were given the land. Again, yes, Niki Shikpone na chole chantane, akeyancheme in 1865. Shimon kake Mukose land se inye macho Mukose land se eni edaleyo eni ejioshishiye ke eni eagbiona ye ni na ke shipon ha icheme ibejeme no ile kusumi na afe ni alo ndoko na amefe ni wana ke shipon ame ni midenche kake Mukose inu munake Mukose inu shishi. The witness under cross-examination by counsel for the second defendant indicated that he knows nothing about the lands acquired compulsorily by the state for the police depot, and does not know that Abola Piam family put in a claim to Lands Commission for compensation, and that he had no knowledge about matters between the government and the second defendant on the whole area, including Chantang. Abola Piam be a king government. Elekula ni akema police depot. Ele wake Abola Piam be a government ewu amenyomo. Yeshipon ni amekeha government le kulapo. He stated further that he does not know anything about documentation of land by the plaintiffs. Neither does he know any of the land issues between the plaintiffs and the second defendant about Sowutuom lands. He said he did not know the issue of Mukose lands and that he was not in court for the land that was given to them within the Mukose land. Egalena, elesane kokrai. Enako wolokwe ne le shipon sane kokla ni yo nyeme nyona aten ni ti Joshibi ke Abola Piam bi e wache ni ya ele sane ko ni ya amete ni le de nche to mo be na enwe ke chon ye shipon na ga ni me no mi ebejame. Counsel for first and second defendants in the second suit associates within the cross-examination made by counsel for the second defendant in the first suit. Wow, we've been reading for over 2 hours. Let's go on. Jeremiah Obobisa was subpoenaed before the court by the plaintiffs to give evidence. So, Achemoko, naturally, Jeremiah Obobisa, once again, Joshibi Nikeneke Bomoneba. He said he works at Lands Commission as an assistant lands officer. He brought to court a file from Lands Commission and stated that the Nicolai's two family applied for compensation in relation to the government acquisition of land at Sowutuom for the sports complex on 22nd July 1975. So neke Jeremiah Obobisa ne Joshibi echele ni na me chele na bile sanie eke wolo ko ba ni wolo eke the Lands Commission le assistant lands officer ni neke wolo ne echon in 1975 22nd July Joshibi enwe ame market government here ni apeame ya neke Sowutuom shikonjine. He said Asere Oko made the application on behalf of the plaintiff's family. Again, watch ni make application koni neke sports complex ni government called 1975 ni apeame ya Joshibi anajan achole Asere Oko. He tendered the document as Exhibit J and it relates to claim for National Sports Complex, Executive Instrument 61. And a cross-examination by counsel for second defendant, it stated that there was no site plan attached to Exhibit J, and no compensation has been paid since they have not submitted all the requirements as other families have done. Eseke beko abile sani na jele na defendant say I'm a lawyer say bi neke Jeremiah obobi sani sani ege dabi Josh bi application na me fe aka pay am compensation for neke sports complex name I pay am because ni amemba ame ni na me wolu na me ma I make a plan fit I no na make a plan fit I government pay am no because many men are pay fair. I make a plan can it be fit I. Under cross-examination by counsel for third defendant, the witness said he knew nothing about Executive Instrument 61 made in 1975. Let me again Executive Instrument 61 then after 1975. He said he was in court just to tender Exhibit J, which is an application for claim which did not mention Sowutuom. So again no konele we a chair Sowutuom le eba ne ka wolone baba keke. He continued that the plaintiff's site plan, which was submitted to the Lands Commission, was rejected because the licensed surveyor did not sign. So the Lands Commission could not continue with the plaintiff's application. Jenny site plan ni Josh B application amekeba site plan po be site plan ni semini amekeba fitai amekeba Lands Commission I reject it because surveyor ni ete survey na kan shipon esai na kan wolo so no aye awomi. Emmanuel Mate gave evidence on behalf of the first defendant, Water River Authority. He stated that he works with Water River Authority as the manager responsible for land acquisition, compensation, resettlement, and related matters. That he did not know the plaintiffs in this case until the case came to court. Nege Emmanuel Martin, again go about Water River Authority. I'm a shikpon sajinfe, legi manager. Legi money ko I'm a shikpon emoka about pay moko about GM ko meka ya ko no very ko I'm a shikpon ye lele. Nege Josh bi ne eliame e ka make go down. Until nege sanene ba ele kwa Josh bi ko ye ko ni nege shikpon ne ameka ma me no. That he knows the second defendant. He does not know the third, fourth, and fifth defendant. Second defendant, eleji wacha yayade. Wacha yayade ele wacha ni yayade elele. She other defendant say eliame, but that defendant say so mo jinya ke ni biye kumeni fita ye. I mean, once again, these cases are consolidated. He dated 13th August 1979, that was executed by the second defendant to VRA as evidence of the land that was acquired. In 1979, 13th August, there was a ni ayadi, le sign wolue ni akeshipon ha Water River Authority. He tendered Exhibit 3 in support without objection. He stated further that they are not in unlawful possession of the land. Again, shipon wa elo jugba. Wakoko shipon ye for me. They validly acquired that land from their grantor. Prior to the acquisition, they did searches to find out who actually owns the land. After that, records available indicate that official searches were conducted at the Lands Commission, and all the searches and due diligence done indicated that the Abola Piam family is the owner of the land, and indeed, they had registered their title of the lands at the Lands Commission. So nege wacha mantene ni le ko Water River Authority. I'm a shipon sanjinfe. Eke before na me ba shipon. I'm a fear me searches. Na sana me kwafe ame kwaje me. Me ne sana me bia me sanjinfe ame bi sanjinye. Na sana me chomo fe ame chomo. Na me chomo je me fe. E ba fe frank amake. Neke shipon ne na me yuo. Abola Piam biye ame shiponi. No ame domo. Dani ameke Abola Piam biye dilie. Let me take a little breather. I will be right back right after a second. Yes. Chemekanyame. Minda nyefenshi akenye biolo. Ofane bomodeni ojani femo. Kiamuko no kiamo. Hello manye. The only authentic Abola manye. Eba fita way. Mo femo ni awe. Yes no na the authentic one. Authentic one. Abola manye. It's in the building. Ima mbodo manye. Ofane boy ojugba. Ima amele. Okay, very confusing. Oh naga. Ima amele. Ni mo ni kanyo. Farm oh a fan wa near fan. I don't know how confusing this is for you. Anyways, Elfane ke o like go show like mo show am yonu. Jani fe mo kiamoko ni lewu ekiamoko. Nya wacha no. So watch maintain ni le ko Lands Commission sanjia here le no eyu oni before ni hie ani wala aka me fi am search am you no fe no am kwaye na sana me kwa me yae na me te Danny ame eshipon ye Abola Piam die. He continued that they have been in possession of the land for almost 30 years. And to establish their possession of the land, the VRA used a bulldozer to create lanes along all the four corners of the land for the land to stand out as being in possession of the VRA. They come eshipon ne 30 years ne ni ake amentani mo femo ayose ake ne keshipon ne mokononie ameka bulldozer Jeshupoi, Edge, Bolly, North, South, East, and West. I'm a fefe. Mokonomi. That they also planted trees along the entire periphery, of the land to demarcate clearly the extent of the acquisition. Ni ameduche hu koni ena ameshipon Joshi ye ke na ye ke bolefi ameka bolefi koni mo fe mo anake ameshipon e dalene. VRA also commissioned the Town and Country Planning Department, which prepared a layout covering the land with a map showing how the area has been laid, and this was submitted to VRA. The witness tendered Exhibit 4, a letter from Town and Country Planning Department. Okay, now I'm a contact Town and Country Department. Now I'm a trauma. Boni na kaya kuchu emiye eshikamo fe yo na noni angmeha me ame tender in. Under cross-examination by the plaintiff's witness, the witness stated that they identified encroachers on the land and reported to the National Security, which involved the District Assembly, and the decision was taken to demolish all unauthorized buildings on the land. I mean, yes, baby, under cross-examination, biane Joshi bi eba ebi watch maintenance ani. Ni kalake ni amenake me eba shikpono ame National Security ni ake District Assembly ewe ni ame aha me egbe. Ni amekumo chunkeni bi fe ni yono. So VRA had been in possession, and was as a result of their complaint that led to the demolition of unauthorized structures. that whenever their attention was drawn about encroachment, they exercised the acts of ownership and stopped the encroachments. Okay, anytime I'm a stopper, man. That it was not until 2000 that Nikolai came to claim that they had a stake on the land, but they did not establish anything. What a maintain le ko Water River Authority be a shukonji I mean she 2000 bena mana Nikolai wekueba ake amenwe shipone eko ame eko shimon ameke no go clear ba ni ba cho ake lele neke shipone ame no ni. They did not come with any valid document, and searches at the Land Commission did not reveal anything in their favor. And there was no basis taking any action since they had validly acquired the interest and sought to protect their interest in the land by going ahead to do the demolition. I can need a new call I be in there, Bane. Amekawoloko ba, Amekawoloko Eja Lands Commission. Ni bani via rebi anake o lele. Shipone Nikolai we be ano. So ame fo ame dapo ni ame teno ni ame kumoni bi ni ame bakumo. That encroachment on the land started in 2000, and it was around that time that they took the necessary steps to stop the encroachers. Benjamin Ninja Mensah gave evidence on behalf of the second defendant. So wache ni Yaya Adi leo mogo baye odase ehale nakamo achole Benjamin Ninja Mensah. He is the secretary to the Abola Piam Bawi family and has been its secretary since 1997. So wacha money by you Benjamin Ninja Mensah leji Abola Piam weku New York Bawi leji I'm a secretary ni FA I'm a secretary ke 1997. Abola Piam Bawi family hails from Abola Gamashi in Accra. He has the power of attorney, which was tendered as Exhibit 1 from Joseph Yaya Adi, the acting head of the Abola Piam Bawi family since 2000. So, what Yaya Adi, what Benjamin Ninja Mensah, ni ebaye odase ehale. He stated that they have a statutory declaration made on behalf of the family by Ni Amponsa Ankra on Sowutuom lands owned by the Abola Piam Bawi family. So, I'm in Chono Gwake, I'm in Yewolo, ni wache ni achole ni Amponsa Ankra ni efe neke wolone Abola Piam weku ni chonake neke Sowutuom shiponji ne Abola Piam weku amameno. He also had with him the plan of the Sowutuom lands. Enye no pe umpe she enye plan ne cover Sowutuom shiponji efe. That the statutory declaration was made on 21st March 1969, bearing the signature of Ni Amponsa Ankra. Ni Amponsa beleji Dr. Jesse Ankra ni alo jenanga alo echemo okay. So wolo una ke ba ge wolo ko keke shilele wolo ni chono kwake I declare na register ne ke shipo 1969 ton na register 21st March 1969. Intended it as exhibits 2 and 2A. In continue that the general public was made aware of the ownership of the Sowutuom lands. Okay, kaji Josh bi ake na register ne ke shipo 69 ton ake ha moku alo ake to te amemale wani meli ake shipo ne wa register. The general public was informed through a publication in the Daily Graphic on 21st January 1967, and intended Exhibit 3 in support, which he read out. Ne balenwe neke Daily Graphic ne ni wache ni Yaya de echita biami ni leun responded to neke suit ne wache ni bastu secretary ni ba Benjamin Ninja Mensah enye Daily Graphic e go keba ne ga ba choje eji ake na no ene 1969 ton wo wani jele mi friend ake neke shikon ne wa register ni wo no ni 1967, excuse me. Ni court wefenu. He stated that they share boundary with Asere's 2 lands, and they served another notice to that effect to the general public through another publication in the Daily Graphic of 28 January 1966. Okay, ameje wusu. Asere me mo elelen, ameka Asere me show wusu. No la ameje wani kula. Shimo neke shikon sanene na yuone. 28th January 1968 ameka wo daily graphic mi ni mo fe mo ana ke ne ke shikpo jine na ayu na ele kometo ele Abola Piam bi amame no in connection with Abola Piam lands, i.e. Sowutuom lands, which he tendered as Exhibit 4, which has the same content as Exhibit 3, so he stated. He continued that Joseph Yaya Ade is the acting head and has been acting for 13 years now. And before him, Colonel John Tete Boy Ade, retired, was the head of family. And before Colonel John Tete Boy Ade was Matthew Adote Tete Alote. Hey! You pay attention. Matthew Adote Tete Alote. You pay attention. You pay attention. Ona any eko bacho mi. You see? Ona any komo be ni inche komo no koe. She kole neke padimane eba yo nukpa because enye se jajen she je chese. Ona be na che. Be ringi no ko yabo. Ache adote teta alote reading no ko be reading no ko yabo. No clearly chese. She kole enye se Abola Piam no one eba ye we ku nukpa. E so onyo wo nye se ni nge o chese. I hope I get follow it. O na any nka ya. Be na introduce you no go ke babie. Sempe be ko ye bie. No akena kan mo eye we ku icho na eye ku icho because of enyejagen. Onyo wo nye se ni kan o chese. Once again, this is conjecturing. But nina sempe gbe ko bia ona ani iantena ani iantena nyangwe. Oh man, let's go on. He continued that the land that the plaintiffs are claiming, which the VRA are occupying, was given to the VRA by the Abola Piam Bawe family through the joint heads of the family. That was Charles Okai Boche and Matthew Adote Alote. Hey, you see? Onyo clearly NSMP Benny. She obana kakena mo eyonukpa because se kole nyese Abola Piam. Onyo nyese ni gen chese. You cannot. You can. I may be wrong. Once again, I'm just conjecturing. But in a sempe be ni ni ball antenna eteshi. Ona rabbit ESA. Antenna be energy rabbit ESA. Oh man. A document was issued to evidence the transfer of the land to VRA. An indenture was given to VRA. The land was given to them on 13th August 1979. The document was executed or signed on the part of Abola Piam Bawe family by Charles Okai Boche and Matthew Adote Alote and VRA by Kingsley Hayford, dated 13th August 1979. He tendered Exhibit 5 in support. He continued that he has heard about Mukose and knows where Mukose is, and that it lies on the north of Kaneshi, then Bubuashi, part of Abeka, and that Mukose lands are owned by the Nikolai family of Asere Joshi. That there is a judgment from the West Africa Court of Appeal, Gold Coast section on Nikolai family land at Mukose dated. Look, Kejo Abola Piam family, you are young and you are educated. Niote school, I'm begging you, go back. Go back to your family. Go back. Go back. No awami. They need you. All of these records must be protected. It must be kept. Ming pabu fight. Call nye say yajeme go back. Abola Piam be ming penye fight. Nye yashia. Nya wa nye make nye cheme. Make yemi amen dala ming penye fight. If you are watching me, look kwemi no lemoko ne Abola Piam. Ne te school ne shenye. Kela you kemola ke papa chale yashia. Bofebo nishia yo ya. We need to go back. Ediwa echo wa many one ya school one face somo ucho wachemeka wanyeme niba wazina ziba wana ame babon san lami J1 ame baja nake lala na ko yanananum sumabusum. It's a stupid song. Nagalala kaladon nayedi yabesum yewa. That is a very stupid song. It's a colonially minded stupid song. Yanananum sumabusum kala. Even that song does not glorify God. Nagalala ejie nyumboji. Oh nananume amejawong. They didn't sum abusum. It's a stupid song. Stop singing it. Ning palamo. So go back. We need to go back. Those of us who are educated, what they school, ni wale wolomi, ni wale nyungmo. We need to go back and fix our homes. That is why you have these people, these leaders. Now me patang be here. Go back. Abola Piam, go back to your family. Go back home. Fix it. Gamanchana yo fe nyenye no she anje fe eje many men na other way be fe yabi son na fe other way fe me nye fe gamanche se fe Abola Piam tuma we nyenye no ni. Go back and fix it. Oh. Yeah, uncle. Ovane. Uncle. Yeah, Ovane live. I'm not gonna match abon. Ovane, yeah, Shibani.
Okay. All right.
Okay. With Mukoseland, but the VRA land for which the defendants have been brought to court does not form part of the Mukoseland. Again, yes. Eliake neke Mukoseland's name. Aye. Your privy council blamer. She go on your neke Sowutuom Sunday. Mukoseland say if it I a chombo any Mukoseland say yo a chombo ke no kaneshi ke chwa bekan ke chombo jam fejege neke Sowutuom shikon na yo ne neke privy council no na ye neke Sowutuom shikon di ne ebemi. He stated that the government further paid Abola Piam with family compensation in 1956 in relation to the winning of gravels on part of Sowutuom lands. So once again, in 1956, government pay na chaya Sowutuom lands like in compensation a pay kin Abola Piam in relation to the winning of gravels on the Sowutuom lands that they registered the cemetery on their land, that is Abola Piam family, on 23rd August 1989. Go only your jame among register Abola Piam 1989 intended exhibit 6 and 7 in support. Look, we need the young folks to go back home. Go back home. Go back home. Abola Piam be all over the world. Send your kids back home. Show them their roots. These must be protected. Chemene amenbo. Amendala, they will die. We need the young folks to take over their affairs. Intended exhibit 6 and 7 in support. He also stated that the cemetery as a site plan and it is on their land, and from 1989 today, the plaintiffs have not objected to the use of the place as a cemetery. I'm again go on when we were registered 89 to register. Josh be I'm back now me no he also tendered exhibit 8, which shows series of correspondence made in 1965 and 1966 about the use of land in relation to Abola Piam family, where the Nico life and Abola Piam families concerning Mukose lands. He also made reference to exhibit 9, which is on compensation for land at Sowutuom acquired by government. It is about compensation payment for land acquired for police depot at Sowutuom by executive instrument 10 in 1960. He also tendered Exhibit 11, a document from the police headquarters dated 1st February 1977 on Sowutuom land addressed to the secretary of the Abola Piam family. He also tendered Exhibit 12, which released 1/3 of the land acquired by the police to the Abola Piam family in 1977. He continued that after the release of the land, they granted portions of the land to individuals and organizations. The organizations, he said, include the Volta River Authority, the Roman Catholic Church, Maranatha Bible College, and the Pentecost University College. He made reference to Exhibit 3, which is the indenture covering the land the Abola Piam family granted to the VRA, the first defendant since 1979. So the Abola Piam came prepared. They had all their documents prepared. They had their arsenals ready. They had everything to show proper allodial ownership of the lands known as Sowutuom lands. He continued that after the release of the land, they granted portions of the land to individuals. And let's go on. The witness for the second defendant continued that apart from the acquisition for police college and training school, there is a large portion of the land, that is the Sowutuom lands, belonging to the Abola Piam family, which was acquired compulsorily by government in 1975 for National Olympic Sport Complex. It was acquired by Executive Instrument 61 of 1975. It's an inumu aite taki enye ne shwani ni eshwa ni mokogbena esani Abola Piam biye nye ya kotu ni mo femo na tole manche Sowutuom kotu a stripile na ka manche yelie ninye nye denche nye to nye manche kenye sumo nye fia ni aite taki manche no ne koje me because ko ye manche Sowutuom pwe esani koba ne ke Sowutuom land sefe mo femo ni ye manche Sowutuom ni je Abola Piam biye tole Abola Piam bi you need to go back to court. Nina kemo a strip le manche yelie. I mean, come on, look. I mean no harm to anybody. I hate nobody. We need to do the right thing. Esani odido anukwale odido ewo ho. Ni wanu nechawo. You understand what I'm saying? Na kanjeme femo ne to manche ya jame ne je na kan manche dia Abola Piam biye you need to take the person to court. He tendered Exhibit 13, which is the second defendant's claim for compensation for their land acquired for the National Olympics Complex site. He also tendered, look, ke ashishibu no ye court wolu ni chwa ka ashishibu ke send me ni tete TV onu makande ni mani tete fa na ka ashishibu ajebu awi. He also tendered Exhibit 14, which is made up of a covering letter and valuation report plus site plan covering their portion of the land that was acquired. Exhibit 15, with Mukose land, but the VRA land for which the defendants have been brought to court does not form part of the Mukose lands. So, Abola Piam bi ameje one yake nege Mukose lands ne Asere bi ano she no fit as Sowutuom land say ebe mieko. Now, he stated further that government paid the Abola Piam with family compensation in 1956 in relation to the winning of gravels on part of Sowutuom lands. That they registered a statement. Oh, I think I get inclusion. In can be a form. Okay, in can be if I can pass it. Complex in can be a woman. Okay, so I think I get a repeat. He also tendered Exhibit 16, which affirmed the decision of the appellate court that the Mukose land is 903.15 acres and not 1909 acres. Whoa! So neke Mukose land in any leleng Josh be not ni Abola Piam in BJ1 year. I mean cholo nake shiko 903 land spare appeals court decided in 19 I mean decided okay neke Mukose land ne 1909 she jen 1909 acres. Exhibit 17 was also tendered, and it deals with the document from the second defendant to the chief's land officer in respect of the query site at mile 9 of the Accra in Sowutuom Road, which the defendant says is part of the land in dispute. The witness also tendered Exhibit 18, which in summary deals with the land in question, known as Sowutuom lands belonging to the Abola Piam family of Abola. A receipt covering the cemetery of the Abola Piam family as Sowutuom, dated 23rd August 1989, was tendered as Exhibit 19. Exhibit 20 was also tendered, and in it is found Ofanko village, and there is no part of the Mukose land mentioned in the document. Exhibit 21 was tendered, and it shows Abola Piam sharing border with Asofan, and it also shows Ofanko and the police depot. Exhibit 22 was also tendered, and it does not show Mukose described, but Sowutuom is shown on the map, as well as Ofanko and the river in Saki. He indicated that there is a deed of conveyance from Charles Okaimboche and Matthew Adote Alote, joint heads and lawful representatives of Abola Piam family of Accra, to the Heart of Visitation Ministry, Accra, and both parties signed it. Under cross-examination, the witness stated that prior to making the declaration, they made publications to the whole world, telling the whole world that their lands lie, the boundaries they share, and other neighbors 2 years before they did the publication, so they believe the plaintiffs would have seen the publication. And if they had any reaction, they should have reacted to it. So, Abola Piam be about Neke. No, nani Josh be a kake. Na me register ni ameke toe. Na me ana. Abola Piam onukpa ni ba Benjamin ni Jan Mensa, I believe. Egarabi. Ni enu wafia for 2 years. Wani mo fe muli. Ke Josh be no ko here. Isana me ba you wa register no ko ni wakabate. He stated further that they had already owned the land, and the declaration was just to register their interest in the land. But already before they did the declaration, they had already granted some parcels of the land to individuals and organizations. Amegana shipone wa onye che. Wa register koni manfre ayos ya ke shipone wa no before ni wa register po denche wala nche wa ke shipone ko me ha ime omo. That the publication was made to alert the whole world to know that the land belongs to them. It was made on 18th January 1967. Okay, yes. I'm a register. Koni jele mi fe na meka tro jele mi fe ni mo fe mo na ka shikpo je na ka Sowutuom shikpo je fe am Abola Piam bi am amenoni. That the correspondence between the plaintiffs and second defendant on the lands ended in 1966, and there was nothing that followed till this case came to court. That as far back as between 1965 and 66, they were claiming a portion of Sowutuom land to be part of Mukose land, and the Abola Piam family reacted, making it clear to them that was not part of Mukose land, and that ended the correspondence. Ni tragebon na ke letter ni amengma watch ya de ke amechemengma sister no kwe ne ka na ni amengma letter ba wo reply ni wo ka ma ke na ke shikon je amame no ni no jino ni gbe na kan sane na no se mi wonu no ko keje amenadon. He also stated that they do not share boundaries with the Mukose lands. They have settled that matter, and they know where Mukose lands are. They are nowhere near Sowutuom lands. Continuing with cross-examination by plaintiff's counsel, the second defendant's witness stated that at the time the land was granted to the VRA, the land was bare, There was nothing on it. That was in 1979. So if subsequently somebody has encroached, he cannot tell the VRA were taking care of their land. Once again, Volta River Authority in 1979. Shipon no go abeno. No onyo kwose se mi no ba kaka shipon obononi. You cannot do that. He stated further under cross-examination that Ofanko Manche was approached for winning gravel on the land because the Abola Piam have people with the Ofanko Manche and they were taking care of the land. So the district engineering sent people on the land to win gravel. They were driven away by the people of Ofanko and Abola Piam, and they subsequently wrote that they wanted to be granted permission to win the gravel subject to paying compensation. So that was how it happened. About winning it, and they are continuing. No, the make me chana me ya unato ni aite takikeba. O manjo. Never kwake ba efio ka Abola Piam ni atla ma tu na gbe ame te acholo. Keje chuchu. Ne chono wa kedeke mene engineering bi ne ka me ba wo sure me. Ofanko Manche at the time Abola Piam bi ekele tuoni unu wo sure ma unu agbeneke abachate apio shika Ofanko Manche ke Abola Piam. Samuel Amataki was subpoenaed by the second defendant to give audience. He works at the Land Valuation Division of the Lands Commission and has been working there for over 20 years, he stated. So, Achemokweko, watch I had the Chemokweko ni mo about you, that's yale. Nekemo, Ebeji Samuel Amataki, Lewo Echuni, Lands Commission for over 20 years, a 20 evaluation department. Me, you know, lewe ke court to it. He stated that he was in court because he was subpoenaed to bring some documents to court. And he had the acquisition for the police depot site, for the police depot and college, as well as the valuation report for the Ghana Police College side parcel of land in the area of the Accra in Insewan Road on Mile 9. Acquired for the Ghana Police Depot and College, donor, the Abola Piam family sub. Okay, so I'm gonna take le clear. So nege somewhere takine ile we tuni over 20 years ele wa keleba ni mne ba mi de ke documents ba ni chuake leleng neke police depot ne Abola Piam ke hanina me ke evaluation as an because the evaluation department clearly neke evaluation clearly e chuake Abola Piam bi ama me ke wolu e ba na fe evaluation koni anya fe by the late Alhaji Isaka Inusa on behalf of the Abola Piam family neke Alhaji Isaka Inusa, Alhaji Isaka Inusa. Like valuation ba on any other on behalf of any other people, but ba on behalf of the Abola Piam family. Now fe neke valuation Abola Piam family. He tendered Exhibit 23 in support. He also had the proprietary plan for the police depot prepared by the Land Valuation Division in 1980, which was tendered as Exhibit 24. He stated that the proprietary plan captures the various interests of anybody whose property or land has been acquired by the government. Those who had applied for claimants, those who had applied for claimants are the Sempe Mensah family. Bona alote Mensah kwe. Bona Abola Piam family. Sempe Stool. Ni Odatelamti and another Na Dode Akaibi II are the only claimants whose documents were received. On the proprietary plan, Ni Kola Stool of Asere as claimant is not found. Ni trageneke police depone meni mengma aka ha me no kofina kompana mefe ana eko keje ni Kola we be the ake ameke apeyame. He brought the acquisition instrument for the state land site for National Olympic Sports Complex 1975 with a redesignation of the sport complex into a residential area and a new EI in the year 2000 tendered as Exhibit 25. He also tendered Exhibit 26 and 27 as well as Exhibit 28. He stated that Exhibit okay. He stated that Exhibit 28 as the names of the claimants, their phone numbers, and the total land area acquired with the numbering referring to the number of each claimant that has come in at the time and recorded. He stated that Abola Piam and Sempe are claiming allodial ownership of the land, with Abola Piam claiming 2,438.16 acres, while Sempe also claiming the size 2,438 acres. But there is no claimant called Nicolai's too. So the case past complex ne Sempe me ke claimite. Abola Piam me ke claimite. The case past complex ne ni akwaye. She Ananoko from Joshibi aka make a claim ko eba. Under cross-examination, the witness ended that Abola Piam and Nicolai families applied for compensation for the National Sports Complex land. He also concluded that the Abola Piam family applied for compensation for the police depot and college lands acquisition. Evidence for the third defendant was given by Samuel Lamte. He stated that he knows the plaintiffs and the first two defendants in the case, that is VRA and Yaya Adi. He said he's in the matter because his company, Ni Oman Mensa Family Limited, as a quarry concession at Omanjo, Sowutuom. Ona, make query ne, no can no more buy, make yeshika. Which it got from the government of Ghana. They acquired a concession or license in 1994 and it was renewed in December 2013. It is renewable every 5 years. He stated that they found it necessary to join in this matter when the Minerals Commission has given them a license to operate, because periodically people go there to harass them when they are working, and others also come to encroach on the land. When they ask the people where they come from, sometimes they'll tell them they are from Asere, sometimes from Sempe or from Adodiakabi, from Abemang. That these people disturb their work, so they cannot plan and do not have peace to work. He stated that all their searches from the time they went there showed that the land on which they are working is a state land which was acquired for the police. So when they heard that there is a case going on which affects where they are working, they saw it necessary to join the case so that the court will protect their interest since they are legally there. And this is the reason why they joined the case. Kevin Takiele true essential, ne true essential, ne essential afeni na we essential atafon, ne kwese te court we, ne yake court ake echuku essential, ni court we enweye. The court rewarded an irresponsible citizen. He stated that he had a search from the Lands Commission and also the instrument by which the land was acquired by government, which he tendered in support as Exhibit 32. The exhibit is talking about him. Last maybe noko aloti, but type he appreciates what I'm doing, but he does not understand why I hate Kevin. I don't hate Kevin Taki. I don't hate the guy. I don't know the guy from Adam. Why would I hate somebody that I don't know and I have no business with? If you think I get me Tabia, I hate Kevin Taki. Your head is in the goddess. Take it out. In America, coming to my favorite graphic, your head is in your ass. Pull your head out of your ass. I don't hate the guy. I hate what he is doing and what he has done to the Gun State. So pull your head out of your ass, Mr. Alopi. Let's go on. That the plaintiffs are the allodial title owners of the land in issue. He also denied that the plaintiffs have judgments in their favor in relation to the land. He also denied that the plaintiffs have granted portions of the land to various people in their capacity as owners of the land. He also stated that it is not true that the defendants are relying on self-serving declaration. So what Samuel Antene le owner Oman Family Limited egele ke me pie ba egbena ake shikwa ma me no me ne ba ka me je sempe moko baba amebaka ameje dodi aka bi ya bema moko baba na amebaka keshi ameje asene no mi shi amehu ne ameba ye shipon amefi ame search ojogba shipon ame ye government di government ani amena executive instrument na ka ye shipon ni shipon ka me kwano fe no mi shipon aye ya Abola Piam bi ade me ni me ba na fe na me ba ko ake ama me shipon ni ame search na me fe twa ake shipon ji ama me no shi Abola Piam bi ano ni keji moko nke Abola Piam bi e fe woloko na me ke wolu eto ni moko aka na me ke nchu ni na ke mo e male that it is not true that the plaintiffs have title to the large tract of land, including the disputed land since long. Nege Mr. Lam tene nile no owner Oman Family Limited. Again, ke Joshi bi aka me ye title ye shikpo jine ni kano ne fe ame male. Ame back title ke jeche. He also stated that they have not trespassed on the land. He also denied that Sowutuom is a settlement of Nicolai's to again na mo di trespass. Now what trespass ko mo go shipon ni Sowutuom shipon we je Nicolai bi ano. He continued that it's not true that Abola Piam family has never settled on Sowutuom. Nike Joshi bi ke Abola Piam bi ame ko Sowutuom da no Joshi bi je na kan yemo je anukwale ni. The Abola Piam family are settled on Sowutuom and can show act of settlement at Sowutuom. And Mr. Lam Tekoe, le private person ni eye company ye shipon no le eba eyuo le eba ni eyuo Abola Piam bi again ake mini ye fio Abola Piam bi manyema chon akeshi ye min search ye min ni bi ni taw mi ni na manyema chon ake Abola Piam bi ame in Sowutuom shipon no da yamoko ke Abola Piam bi ko Sowutuom shipon no da ame male private person never defend us Sowutuom bi because ni shipon le Sowutuom bi ade ya Abola Piam bi ade le na kan shipon government here state land ni ne ya he ne chate ya jame so je Abola Piam bi po ne ya shipon ye de no ba ka ke eba ye ke Abola Piam bi ne ba chata ya jame ya he government here de chi ekwa wo ji mi fe ne na ga oh me yue ma yu shipon le Abola Piam bi ano so le we ba ewe Abola Piam bi po eba join the suit so le we he became a defendant show na a case here ya. He also stated that the statutory declaration by the Abola Piam family cannot be said to be illegal and fraudulent. Okay, no the Joshi bi you ake neke wolone na Abola Piam bi ya fe ye do shishi na meke teni mokomoko ana ege da bi Joshi bi enye ka ake na kan no je wolo papa ni Abola bi fe ye forming. He continued that the plaintiff's land does not affect where they have their quarry. Their quarry. Which is a state land. Okay, Joshi bi no ne ame claim or naga me no e ba query me. Na can query state land. He stated that where the quarry was acquired for the police. The Abola Piam family is stated is a family in Accra for which New Oman Mensa family is part of. Okay, so once again, it will come. So he said he knows for a fact that Abola Piam family have granted land to the Catholic at Sowutuom. He also stated that he has paid his rent, making his license valid. That is his mining operating license from the Minerals Commission, which is an addition to the license granted by the Minerals Commission, which is renewed every 5 years. So let me look. Abola Piam bi no ameno na make shikwen ko Catholic. He tendered his renewed operating permit for 2017 in evidence as Exhibit 33. He also tendered the annual rent payable to the administrator of stool lands in respect of the quarry concession in Exhibit 34. He also tendered the quarry license he applied to tender at the last sitting at the court as Exhibit 35. He tendered Exhibit 36 relating to ground rent. And a cross-examination by counsel for the plaintiffs. So, be Joshi, be eba. I'm a lawyer, eba be neke Samuel Lam teneni le ono ni Oman Family Limited. Eba be le Sunday. Counsel tendered Exhibit J through the witness. The witness also agreed with counsel for the plaintiffs that the company was not in existence in 1994, but that it was in existence before they joined the suit as Ni Oman Mensa Family Limited, and that all the shareholders were involved when the license was acquired in 1994. And subsequent renewals after 2003 were made in the name of Ni Oman Mensa Family Limited, and records at the Minerals Commission will show. The defendant answered that what he knows is that the land is state land and not stool land. Hence, the payment as requested and directed by the Minerals Commission. He also stated that Exhibit 36 relates to ground rents that were paid for Abola Piam family and was collected by the administrator of stool lands in connection with the Sowutuom lands for Abola Piam family. The defendant in suit number BR143/2005 gave its evidence through Grace Abebio. She told the court that she's an evangelist with the Hour of Visitation Ministry established in 1968, and that she is on Sowutuom land, but is not trespassing on the land. It is her land, and what makes it a land is that on 22nd August 1979, her husband and herself acquired that land from the Abola Piam family. She continued that there were a lot of elders in a big hall where they sat together with their surveyor and the elders, and they signed the land to them. Once again, as far back as 1979, these people bought the land from no other than the Abola Piam family. That they started from Santa Maria to give them land, but all that area was waterlogged. So they went up till they got to Sowutuom near a hillside, and she said that was what she wanted, and they assigned that to them. They were given an indenture, which was duly registered with the Lands Commission. The document has her signature and that of Dr. Abebio on it. She tendered it in as Exhibit 29. After objection raised by the plaintiffs was overruled, the document is an indenture granted by Abola Piam family to our visitation covering the land they are occupying, which does not belong to the plaintiffs. So once again, our visitation be a about joining the case suit today because any Abola Piam be a one ship ame Joshi be a kejame ame no me. Eke indenture ni aske hame jameba. I may raise mina chole Joshi be a lawyer said raise an objection. It was overruled. Ni admiti no abo me. Let's go on. She said she owns the legal document that shows that they acquired the land legally, and the land is located at Sowutuom, opposite the Catholic Seminary, on the other side of the hill. She stated that she has personally been on the land since it was acquired. And one of the most important things they have done on the land is to get electricity drawn on the land by Electricity Corporation. They paid for the transformer, which cost about 15 million cedis, and this was in 1979, 15 million cedis. Bring it to today's money. That's a lot of money. They connected power to the place at that time, and when the place was underdeveloped, it was in the bush. So a few households asked them to connect power to their homes. One of them was Heavenly Church. She continued that they planted mango, thick cashew, oranges, grapefruits, a 4-classroom block, an uncompleted block used for a dining hall for the children are also on the land. She mentioned that an interlocutory injunction order was obtained by them against the plaintiffs, but one of the plaintiffs, since the injunction order was obtained, has built on the land and is living on the land. She tendered Exhibit 31 in support of a statement on the injunction order that the school built on the land is in operation and that the land does not belong to the plaintiffs because she has an indenture which was given to them by the Abola Piam family, and it is registered. The land was acquired in 1979. She has reported the plaintiffs several times to the police because they have been trespassing on her land. She reported them to the Sowutuom police station, Odoko police station, Dansoman police station, Ghana police if we. Hey! Accra Police Central Police Station, and ended up at the property fraud office at the police headquarters. Going again. Each time she reported them, some of them were arrested, and one of them was granted bail by the police when Mr. Festus Nikwe went to bail him. Mr. Festus Nikwe alleged the first plaintiff. She concluded that the plaintiffs have no land there, and right now she has acquired electricity to the land with a transformer that is in front of the school, and electricity to the land with a transformer that is in front of the school, and Electricity Corporation is asking her to repair the wall that protects the transformer because it is in disrepair. Electricity Company of Ghana, wall transformer here, nonsense. And a cross-examination by the plaintiff's counsel, she stated that at the time they built the small 2-bedroom building on the land, they had put up pillars all around the property. They had 5 feet tall pillars all around the property and put somebody to stay on the land, and the pillars were put there to demarcate the property, and mahogany trees were also planted all around and in between the pillars. She continued under cross-examination that she has been on the land long before the commencement of the action, and also that those who were harassing her on the land were also reported to the police by her at the various police stations she mentioned earlier, and no one has ever caused her arrest for trespassing. No, 1979 na meshpe ya no eche ni meni me bagbe na afin le ete e ka mete police she le moko kele ya ko police dan agele e by trespassing. That those who sold the land to them were the owners of the land, and they also have given some of the land to Presbyterian Church of Ghana, Lighthouse Church, EP Church, and the lady who acquired it for Pentecost. But now it is in her personal name, and some of them have duly registered the lands with the Lands Commission, and they encountered no problems with the registration, and those who brought them to the court have also sold part of the land to some people, and these people have not been able to register what the plaintiffs gave them. So again, what Washington was here, what can I ekome? What can I Lighthouse? What can I EP Church? What can I Pentecost? So more. Neke bemene fe amenye ame register. She Joshi be na me ba color shikpon jie kome na me ho ya me na me ho ya me na ga me fe ka me te Lands Commission amenya ame register shikpon. Some of these people have come to the defendants to beg them to give them documents because they have gone to do a search and found out that the land belongs to our of visitation at the Lands Commission. Aka ame shikpon jie kome ni Joshi be ho me na me ho shikpon ame ka me te amenya ame register na me te me kome ba ama me ngo na me ba pa me fa yake ama me ha me wulu koni amenye ni ama register ame shikpon jie. Nachije ovane ke gane awo charge ami onu. Thank you. The first witness for the defendants in the second suit number BL 143/2005, Benjamin Nijan Minsan, told the court that he is the current secretary of Abola Piam family and has been the secretary close to about 20 years now. In his evidence, he stated that Exhibit 29 tendered in this court was executed by the joint heads of Abola Piam family at the time who were Charles Okain-Botre and Matthew Adote Alote. He said he met Charles Okain-Botre, who died in 1986, that he is familiar with the signatures of the heads of family on Exhibit 29. And these were Charles Okain-Botre and Matthew Adote Alote. They are two family heads instead of one. And it was the family that decided to have joint heads so that in case one head is not available, the other head will be available. He stated that Exhibit 29 was given to the hour of visitation on 22nd August 1979. The lessons were the joint heads, the lessers were the joint heads, Charles Okaiboche and Matthew Adote Alote, who gave the land to her of visitation. I recognize that counsel for the parties in the two cases consolidated have all submitted their written addresses on behalf of the parties. I will start with suit number 397/2006. I will start with suit number Tafo Amon the second, Richard Kote Addison versus Volta River Authority. Joseph, okay, so let's go. The issues, so no evidence back so let's go on. The issues to start with are A. Kata idon is enough. Oh, you so ke lebi. Kata idon onu. Good. Ya na twin. Whether or not plaintiffs are the allodial and true owners of the land in dispute. And B, whether or not second defendant family has migrated with the guns from Ayawaso. And C, whether or not the land in dispute is an ancestral settlement of the second defendant, as well as D, whether or not Asere's tool has been in uninterrupted possession of the land in dispute from time immemorial. Proof in law, as stated in Majolagbe v. Labi 1959, First Ghana Law Review 190 and 192, is the establishment of a fact by proper legal means. In other words, the establishment of an averment by admissible evidence. Where a party makes an averment and its averment is denied, it is unlikely to be held by the court to have sufficiently proved that averment by his merely going into the witness box and repeating the averment on oath. If it has not adduced that corroborative evidence, which, if his averment is true, is certain to exist. The plaintiff, in their evidence through the first plaintiff's attorney, Festus Nikwe, stated that all the defendants in the case are trespassed on some parts of the Mukose land located at Sowutuom and covering an area of over 60,000 acres. That the Nikolai family's two family of Asere became owners of the lands by settlement when they migrated from Ayawaso to the coast to the knowledge of the Abola Piam family. That after settlement, the Nikolai family /2 had been in possession uninterrupted and subsequently had litigated with other people and have had various judgments which show that they have litigated with other people and have won. That they have the various judgments intended exhibit B, C, D, E, and F as the judgments they had in their favor. It is, however, not shown from the evidence of the plaintiffs that the Lands Commission is or was aware of this development in favor of the plaintiffs. So, yes, Joshi be a chon. Okay, Leleng, wekwe na jayi wasoe na abansho na ameba ni amebato neke Sowutuom shiponjene na kediro ni ameke me pie te kotu ni ameye sanjimbaba o ya neke shiponjene ameke exhibit seba exhibit B, C, D, E, and F ake judgments ni ameye shijaja ke shimon enefe se amenye kona me ba atwo mi ake nege judgments di na fe na amenye American Lands Commission ni lands commission ya where ake ne ke shikpo jine lela ka ma me no ni ame win judgments ye no je ke amenye kwa me trom yake ame ani lands commission ele na kan noko. The plaintiff led no evidence to show and justify that after obtaining the various judgments, they ensured that the parties obey the judgments with the enforcement of the judgments and others through the appropriate rules. Okay, once again, Nicola Webine, ame chomi ake, nege judgment ne fe na amena, ame fe shuake, ame chok beno, ni ba fe shuake, me ni mena ame ke tra. Ni amena neke judgments ne fe neke me ne ba ye judgment ye no nake no ame fe ni ame choko miake ame fe amake neke judgment ne na me ka ame na fe ame enforce so ni bi enyo jeje ke neke judgments ne na me ka ame na fe no ko kra be ni choake ame ani lands commission na eliake ame na judgments. Number 2 me ni ame ka ame twa ye neke sanjine na me ke ba na me ke twa ka ame ye neke sanjine fe na me ke twa ame chom lagbe no ni ame ba enforce ne ke judgment ne eshi me na ame ke twa ni ame win ne ke cases ne fe. The plaintiff, it seems, opted for non-enforcement of the judgments they had. Plaintiff say ame na ame na judgment na ame atashi, and this is why inyemi nuwe koni nke gbasani ekemi noko. I can look. Abola Piam be and share. They need to go. They get judgments. I don't know whether they can still do it, but I believe that they should talk to their lawyers. Now, may enforce. Koni mo fe money choy manche jame liji ama metole. Naka mo hepe manche jamo. Mo fe money hono ko jame ni naka mo ame o ya me ba me. They need to enforce these judgments. They have to. Abola Piam be nyetiashi. Now, the lands commission could have been informed about the judgments of the plaintiffs, which had been obtained, and this would have made the lands commission to register the said judgments in favor of the plaintiffs. And with such registration, it would have been difficult for any other person or party, apart from the party that had the judgment, to have access to the land affected. So, kanji, neke judgments ne fe ni amena. Ame any lands commission lenkwe. And she will lands commission by register ne keshi ko jene fe ya me gbe mi. Ne keji e bale na kan moko nye jame se. Ni mo ba fe no ko alo e ba won shikpo ya moko fi ama me pe. The plaintiffs have not shown what actions they took to prevent people or parties from taking away their lands from them. Ni Joshibi de ame chokomi nona ame fe kedi lele ame ka ame na judgment ni me ba e kolo shikon ame chokomi no ni kola ni ame fe ni ame ke china kan gbe me aka me aka ko ame shikon. No evidence was led by the plaintiff to show that they had prevented their lands from being taken away from them. No kokla be ni chom yake Joshibi ame fe no ko ni ba chi me agbe ko ni na kan me ame ka ko shikon. Yeah, ameding. The plaintiffs also did not lead evidence to show that they were in possession of the lands in dispute, covering a total area of 6,698.726 acres, more or less. Amekenoko klauba ni ba chon akeneke shikone almost 7,000 acres and na you one. Amekenoko klauba ni ba chon ake na kan shikon amamenoni. The plaintiffs did not also provide evidence of overt acts of ownership performed by the plaintiffs, some of which would have been acknowledged by the defendants. Okay, fe no kokla ni Abola Piam bi e bana ni bana amena ke o shikpo ne Joshibi no fe no ko overtly they didn't. Ame fe no kokla ni mo fe mo ba na ka o lele shikpo ne Nikolai we be amameno. The law has been fairly settled that possession is as good against the whole world except the person can show good title, and it would be mischievous to change this established and time-honored principle of law. Na kishikpo nko ye no kebo no it's an ocho title ko nyo ocho title beshikon jono ni nakanji mla keje chuchu ni esa akele eba chake mla ke shikon ko ye no kebo no it's an ocho title ko nyo ocho title nakanji mla lebele jeje enye eba chake keje che nakanka ye shikon ji asane nakanji bona yole eba court authority go ebie. In the Bokosi case, 1902, SARFLR 154, 160RN239, on the incidents of long period of occupation or possession, it was held as follows. Where land has been occupied for a long period in circumstances which should cause occupiers to believe themselves as owners and to improve the land, the court will not supply strict native law and will not restore the land to its original owner who slept on his rights. Once again, so the authority na again na kedi aye shikon sani ni atana na money poten no kedi bi kome ye na sane efe ni na kan shikon mo fe mo ba yo si akele no ni mo efe na kan no eleje court to sani no eleje court sani if you sleep on your rights no eleje court to sani court to kan shikon abo. From the facts of this case, the time or period of occupation by the first defendant through the second defendant up to the period when the plaintiffs took this legal action is really a long time. And the plaintiffs have not led any evidence to justify that they acted within reasonable time. Na keje biami ni Abola Piam biye ho shikon ne ke Volta River Authority be baba o ebawo ni Joshibiye ametro no ko klake amefe no ko ni within a reasonable amount of time I can like ametu no ko eneke no yi ame ani ni echechon sani eche klachon ni kelela amame shikon ni aisana ameba ni pako na ni ameba me una meba fe neke. Now the first defendant was granted a piece of land by the second defendant in 1979, and it was not until 2006, a period of about 27 years, before the plaintiffs took the legal action in this matter against the first defendant and the second defendant, as the evidence show. Again, 1979 no to Abola Piam bi ameke shikon have Volta River Authority. Nike wakawayin wo mie afi nyuma enyo kekpaone 27 years ni Joshi bi atashia u ka me shikon ni ame tashia u afi nyuma enyo kekpao na ni kpako ameba na meba yue noko. No credible evidence was led by the plaintiffs against the first defendant. Akena no kokla be Joshibia ameke no ko poten kokla ba ni ba chon ne ba yue no ko eshi Volta River Authority. The plaintiffs have not led any credible and imaginable evidence, even imaginable evidence to establish the size of land against the defendants in this case. Ameke no kokla ba even no ni abadwen po ameke no go kla ba ni atashi na dwen ameshipon dale po ameke no go kla ba po na ba dwen po na ba gwa go ka wo susu ye ni wo dwen ye even though one wa ime na po ba ni wo susu ye ni wo dwen ake o ka wo kwa na keke shipon dale ne Joshi bi amefe na kan. There is no evidence from the plaintiffs to support their ownership of the land in dispute, despite the judicial judgments which they had during the so na no kokla be ni Joshi bi ekeba ni chonake neke shikon ne amame no, even though ameka amenye judgment ni ameye sajimpi ni ko nakan shikon Plaintiffs showed no evidence of their occupation and possession of the lands in contention. Joshi bi enye chon ake neke shikon ne amame no ni amame nye nakan shikon amenya amechon. Exhibit G, tendered by the plaintiffs, is said to cover the acres of land, but it is a site plan which is not registered. Leleng, amekawa lokoba, ni nakanwolue, wachale Exhibit G, ni nege Exhibit G, ne na amekaba, echon shikon dale mon ne, shimon, ame register ko, no nakanwe. The plaintiffs were unable to indicate or state any activities they undertook on the lands for which they are in court. Okay, once again, Joshi bi enye cho no ko poten ni amefe ya shikon neno. Ni ba ni wana ka ma me shikon ni no ewa meke ba court we. Now, defendants 1, 2, and 3 showed in their evidence activities that they took and continue to take on the lands which the plaintiffs seem to not know about. Okay, Volta River Authority, watch Yaya Ade, ke Oman Family Limited, me yetene clearly. Ame can be ba ni chon ni bi na me fe ye shikpon yi ni chon ake lele shikpon ama amenoni. The plaintiffs are ignorant about ongoing activities on the land in dispute. Josh be a fella nakpe. Amele no ye shikpon na me ba me peli oye. Amele no ye shikpon yi. Na kan je minke. Ketem face as of you. The second defendant in his evidence, second defendant there, Bewacheni Yayadi, tendered Exhibit 10, the Executive Instrument 18 of 1977, and Exhibit 11 of 1980, which showed that about 1564 acres of Sowutuom lands were compulsorily acquired by the government from the second defendant for the establishment of the Ghana Police Depot and College in 1977. Wacheni Yayadi, executive instrument ni government ka yeshikpon ya Abola Piam bi ade ekeba 1977 executive instrument ekeba no na hey na Ghana Police Depot ke college ekana no ba. The second defendant Wachani Ayade Eko also showed that they applied to the government for compensation to be paid to them for the police depot and college land as shown in Exhibit 9. Now, executive instrument pe Wachani Ayade keba Shimon, wolona men makia government here, aka government here appear me. Ye shikpo ne ko for police depot. Nekanwolu ekeba. The second defendant also tendered Exhibit 12, which is a letter from the Ghana Police Service informing the Abola Piam family that is the second defendant that consequent upon a petition from the Abola Piam family, 1/3 of the land compulsorily acquired by government for which the Abola Piam family applied for had been released and given back to the second defendant. Watch it. Ni Yaya Ade. Leo ebomode nekawoloba. Ni Ghana police fuegma. Ake watch it. Onwawolo ake what shikpo ni waye 1977 wogme minja eten kehanye. Ni police fuegma le back yake minja eten nanu wake habu. Ekawolu umba ni chwake police we ngono ake lele shikpon ame Abola Piam ndi no ka Abola Piam mawolo ake minja ajami ete na ke kome ha me lele ame police we ajami ete na me ke kome ha Abola Piam bi. The second defendant in his evidence showed that out of the 1/3 of the land released to the Abola Piam family by the police, it in turn released portions of the said land to the first defendant, VRA and others. Abola Piam bi ameteno ni amekawoloba ni chwanke ni police fue minja ete ni police fue ke ha me ameteno na amejieko ke Volta River Authority ni ameke ekome ha me konklo me hu. The second defendant also gave evidence that Abola Piam family as the land, the quarry site at Ofankor, also known as Sowutuom land, belonging to the Abola Piam family as per the letter of February 1954, which was tendered by the second defendant as Exhibit 17 and 18. Agbenenwe wachani ayade eseka woloba ni chwage neke query ne ni yo Ofankor ni efita Sowutuom shikpon jian efe ameka woloba ni wolu date ni yo no February 1954 ton ni lele no chwage na kan shikpon Abola Piam biano. From the exhibits, it is shown that from October to December 1953, site for Kerry at Sowutuom near Ofankor Mile 19, Accra to Takoradi Road, in Sowutuom Mile 9, were all for the second defendant. Between August, October to December 1953, Query wojine na efe chwanke Ofankor Mile 19, kete Takoradi Road. It's a 1 mile 9. Naka no jame fe Abola Piam biano. On 6th July 1956, Ni Korte boy of the Abola Piam family acknowledged receipts of £80 from the government of the Gold Coast as compensation for digging and removing of gravel from the grave pit at mile 9 for the period 1953 to 1955 on resealing of Accra Takrady Road. On July 6, 1956, Wachako ni Edumo Abola Piam bi anajia na chole ni klote boye government gogosu government pele 80 pounds for share ni acha yeneke alo tai ni acha yeneke eine na kenfe Accra Takrady gbe na kenfe gogosu government pay. The Abola Piam family, through the second defendant, showed in evidence that its traditions are that they have been settled on the Sowutuom lands. It showed that the Sowutuom lands belong to the Abola Piam family. Na Abola Piam wekue ni wache ni aya adedumu amena na ayeneke sanene ame bomode na menya ame chonke kejo bu ade na kenshipon amamenoni na ame injame. The second defendant also tendered in evidence that deeds executed by the Abola Piam family in favor of the defendant in 1979 and in favor of the Hour of Visitation. Ameka wolo umba ake neke deed ne fe ni ameka ha Hour of Visitation be ke Volta River Authority ne as far back as 1979 ameka neke wo jine fe ba ni chon ake lelen be shipon amameno. The second defendant, look, Abola Piam wekue, I hope that's why I'm calling for the young people. Abola Piam family here. You need to go back to your families. 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 Go back to your family. Start working. Protect what is rightfully yours. Go and claim what is rightfully yours. Go and claim what is rightfully yours. Abola Piam bi aye nye chon nye ya nye wa man check papa ni aye ne nunu kenye ba nye kpale e bo moden e gbenyeshi abenu e patashi ya mimpu awo shinye ye shishi aka Abola nye aloje na ke nye fi ekome sana kpale e wa anye e ga menfe ekome na junye ni bi na honye ni bi esa man cheyeli ko bla nu jibo no Abola Piam ya shia ya wa hime ya wa yeme nye kwanye se nye ya shia nye kwanye se nye ya shia nya wa nyeme nya wa nyecheme. The second defendant tendered Exhibit 6, 7, and 19 in respect of its cemetery, which operates on the land up to today and claims ownership of the cemetery as a deed for the quarries. One cannot operate and maintain one cemetery on another person's land without valid authority. Leleng Abola Piam biye ameba nineke ame cemetery ne ameka wojinchon ni chwake amameno ni mokonye ya fe go ye mokoshikpono anmembo be Abola Piam biye nye ya fe go ye shikpon ni je amameno na ameka wojieba nchwaka amame fe go ye na kenjeme be no chwake shikpon amameno. The second defendants in his evidence tendered Exhibits 2 and 2A, the statutory declaration through which the public was made aware of the ownership of the Sowutuom lands on 21st March 1969. But before this, the general publication was informed through a publication in the Daily Graphic of 21st January 1965, I believe, and in 67. And in yet the same Daily Graphic on 28 January 1967 about the Sowutuom lands that belonged to the Abola Piam family. Once again, ameka wolu e ba jekpo ni twage ne keshikpo na me register Abola Piam me register mo ni na me ba register amekete to mo be ni Josh bi e call da bi 1967 here ame make it publication aka me ya na ma register ne keshikpo ne ya me gba mi moko yue no ko na register ha me hu atan no hu ame post ye Daily Graphic e mi no ni mo femu anake ne ke Sowutuom shikpo jin fem Abola Piam no. Now, even though there was comment by counsel for the plaintiffs on the statutory declaration tendered as exhibits to the effect that Exhibits 2 and 2A relied upon, among others, to establish title to the land were self-serving documents, my own observation is that every document of title to land must be considered on a case-by-case basis, and no general comment must be made to denigrate statutory declarations in view of the high illiteracy rate in the country. Even though Josh B and Kake neke nokone na mafe amefe ni ameke cover me na amefe lo juba dabi leke na kanchuni every single one is an equal case by case ni anya fe no kokome na akba buffet because school ya fa chon ye womami. The plaintiffs in the instant case had opportunity to respond to the second defendant's publication in the Daily Graphic of 21st and 28th January 1967, but did not and gave no reason as to why no response was given. Negeno kone na menchele self-serving Abola Piam be a fair na me fair do me na make it clearly I me fair do me I make a graphic me ni na make a graphic me ke Josh be ye no ko yue mo ye na kan bia mi to sana me yue no ko ye hia me yue no ko ye no ni ame keko wo no na woni na kan bia mi ame yue no ko ye. It is not always the grants of land made in pursuance of a statutory declaration stamped as registered could be refused. It is clear that the second defendant showed by virtue of exhibits 2A and 4 that before the registration of Sowutuom lands, 2 public notices were published in the Daily Graphic of 21st and 28th January 1967 before the statutory declaration, which for so many years from 1969 to date are not been challenged, and it serves that second defendant which uses it in controlling and managing the land conveyed by it. So once again, now leleng Abola Piam be I'm a register shipon ameke tehu ameke chon mukwe jie wanie mukwe teshi ewe mukwe shi ameke chon before now I'm a register ameke chon ni a register am one time ameke ba wo graphic e minimo femo na mukwe we ko no gwe ka bata bia ne mukwe we ko ni no amedumo ni ameke fe no na me ba fe ye shipon hi oh Dabi. Mention. Imba ni ejo fu egatation. I think I can watch it. I think I can watch it. Okay, yeah, this is where we are. In his evidence, the second defendant's representative stated that correspondence between the plaintiff and the second defendant ended in 1966. And there was nothing that followed to the present case in 2006. Remember, I can watch it near Yaya de Chondo Kwake in 1966. Josh B and Mawulu Abola Piam ni ameba tashi ni aywe neke mukose shiponji ni amejena kaja no se jaje ke neke weku neke Josh weku neke Abola Piam amewe ko shipon is done until neke saneneba in 2006. It seems the second defendant has been in possession of the land in dispute for about 39 years before the present action. From the evidence before this court, it is clear that the second defendant has shown remarkably, I believe is the word. I believe the second defendant has shown remarkably that the Sowutuom lands in contest belong to the Abola Piam family, and the Abola Piam family is also in possession of the Sowutuom lands and has also been for a longer period, which is recognized and worthy of protection against the plaintiffs who have not affirmatively proved a better title. Once again, what you need a yadi and Abola Piam be here. Na menya me prove wa akelele shikpon amamenoni ni ameyin shikpon for a long time ni Josh Biele ameyu no go kra ni ba ni jeje anake o lele shikpon amameno. Once again onaga bi efa use Sowutuom lands so call na ni sempe alone namoko nimon separate oman jaw from Sowutuom kabwa metwe amenta make share awo imbemi. Oman jaw is not separate from Sowutuom. It is part of the Sowutuom lands. Okay? Kona ni sempe mfe na kanye. Maybe ekole jomo begeme na kai. Shimi na kai nale. Ni sepe nteke miake. Kenje chono no nshe joshi. Ni sepe ke teke miake. Oh, Dabi, Jemo, forget mo Joshi. When you gamashi sani, Joshi bemi. Dabi, ka you gamashi sani. Onyo kake Joshi bemi, Joshi yemi. Onyo kake chono bemi. Alon chono kekbe. No ya je bukon. Ni sebe ke oh Dabi je bukon sani ayu chonos ayu gamashi sani. Dabi bukon ye gamashi mi. No akona na menke ayu man Josani ayu so Dabi ka fo ameda. Sowutuom fe Abola Piam no. Ene Abola Piam ke mene ke Asere bi ene wo mababie obafe Abola Piam ke sempe wo obaba Abola Piam ke sempe wo fe rich nyama kwi dabi wo bato be konklo obafe Abola Piam ke sempe wo. So when dealing with Asere bi aside the obaba ke sempe no le ngo bana. The Abola Piam family's acts of ownership that sustains occupation and possession of the Sowutuom lands have not been shown to be open, undisturbed, and unchallenged, for no resistance or opposition has been shown. Once again, you understand what I'm saying? Let's go on. The first defendant in its evidence through Mr. Emmanuel Mate, Legi Volta River Authority, I'm a manager in charge of lands. Legi Moni Ebadumo Volta River Authority biana jam biamini wankande proceeding say nite no ye court mi ke obebi biamini nkande le ejino stated that he knows the second defendant as the grantor of the parcel of land that VRA acquired from Abola Piam family. That the second defendant in the late 70s bona Mr. Mate Emmanuel Mate gele wachayayade wachayayade jimoni Keshikpon Volta River Authority in the late 70s, that the first defendant, as a conveyance dated 13 August 79, executed by the second defendant to VRA as evidence of the land that was acquired. Yes, and you will know what any ayade sign ni akenekan Shikpon Hame. Intended Exhibit 3 in support without objection and stated that they are not in unlawful possession of the land which they validly acquired from their grantor. The first defendant, according to Mr. Emmanuel Mate, prior to the acquisition of the land, did searches to find out who actually owns the land, which showed at the Lands Commission that Abola Piam family is the owner of the land, and indeed, they registered their title at the Lands Commission. Once again, Mr. Mate, ni wakane proceeding say, before now me pay shika, I'm a search. I'm a Sanjine sana me be ni lele Lands Commission prove ya make ne ke shikpon ne ni Sowutuom shikpon jine Abola Piam be ano. He stated that they have been in possession for almost 30 years, and to establish their possession of the land for almost 30 years, they used a bulldozer to create lanes along all the four corners of the land for the land to stand out as being in possession of VRA. They planted trees along the entire periphery of the land to demarcate clearly the extent of the acquisition. It's commissioned Town and Country Planning Department, which prepared a layout covering the land with a map showing how the area had been laid, and also drove away trespassers from the land. The first defendant continued that they exercised their acts of ownership and stopped encroachers. That in the year 2000, the plaintiffs came to claim that they had a stake on the land, but did not establish anything. The plaintiffs went to first defendant with no valid document, and searches at the Lands Commission did not reveal anything in favor of the plaintiffs. So now VRA once again proceeding said no can you san can but judge and repeat it. No name Mr. Mante you ain't can abo form Mr. Manteba they bakake look what kwani bi am yojoba than wa Shikpon ya Abola Piam in day somewhere in 2000 there Joshi bi eba na me kake na kan Shikpon ma me no na me ba me ke wo loko ba me ke wo lo echon no ko cry Lands Commission ni chwanke ni ke Shikpon Joshi bi ano. It is clear from the first defendant's evidence that the plaintiffs had nothing to depend on to claim that the land is theirs. Clearly, Mr. Mante Odasi and Eba ye, Josh Bieke no Koklaba, ni Amebadomono, ni Abakake, ene wo, Beshikon, Amamenoni. The plaintiff could not show any documentation to rely on before the court to show that the land in dispute belongs to them. Ni court to Abanye Queno, ne Bakake, oh, we are one in Yaka Bapone, Obanya Wakono, ni Wakake, Bueshikon, you know, court to a Joshi Bie, Amaka Loko Klaba, ni Amebakono Pony, and Bakwake, Buene, Yenoni. I find that the first defendant showed effective physical control or occupation, evidenced by its acts of planting boundary trees, demolition of houses, and properties of trespassers. It also registered its interest in the land and has been in possession since 1979, when the second defendant made the land available to the first defendant, as shown in Exhibit 3, which is the indenture in favor of the first defendant, VRA. The first defendant has been in occupation and possession since August 1979, about 37 years before this court action. Having been in occupation and possession for about 27 years before this court action by the plaintiffs, the first defendant has proved possession of the land for more than 12 years, as required by Section 10 of the NRCD 54, which makes no action to be qualified to be brought against the first defendant to recover the possession of the land by the plaintiff, if even the plaintiffs were to be owners of the land in dispute. Ene ache jeme non nogo yekpano. So look, VRA ame shikpono for more than 12 years. In Section 10 of the NRCD 54, look, this observation stands for something. When you are unaware, for 12 years. Joshibia were to prove because mene in Germany for over 12 years. Anya Shipon Yevota River Authority BRD based on Section 10 of NRCD 54. Let's go on. I also find in respect of the second defendant that the once again look, Abola Piam, it is my prayer that you will find another Niyaya Ade in his absence. The man is old. He's over 90 years old. Eda Bonia Bale Kanaka Yale at some point about choice. And I hope there is somebody to step in his shoes. And that is why, like I said, we need the young guys. Go back to your homes. Go back. Help your people. Help these old people. Nibi Echake. You guys, Nibiami, by reason of Bonnie Jele and Echake, Nibi Echake, go back and help. Look, help. Onyo challenge numbo. No bi aga numbo. Mabo bomi no kami woneke wekumi. Go back and help. I also find in respect of the second defendant that the Abola Piam family showed its possession and ownership of the Sowutuom lands, which it had documented and registered at the Lands Commission. The second defendant was able to establish by a preponderance of probabilities that the Sowutuom lands, as identified in this case, belong to Abola Piam family. Once again, this is the judge speaking. The Tumawe family of Gamashi, the exhibits tendered by second defendant corroborated the evidence of the first defendant as well as the exhibits tendered by the first defendant. I find the second defendant's family as being in possession of the land long before registration in 1969 at the Lands Commission, and also showed acts of that the Sowutuom lands, as established by the second defendant, belongs to the Abola Piam family and is in its possession. Amamenoni, Abola Sowutuom shikpo GFN, Abola Piam biano. Let's go on. The plaintiffs had the opportunity to show how they owned the Sowutuom lands as well as how they had the possession of the said lands, but these they failed to do. Joshibia, they were given an opportunity ne sana amechon no ni ba ewo alo gbeno ni cho ni ameke Sowutuom shikponji amame no ni amenya amechon jeje ke amenya amechon. From the evidence, it seems the plaintiffs do not follow their rights to ensure that whatever was their land remained their land. Jeje ke ye no ni ke yin fe ne kwe Josh bi ekeji ameke Sowutuom shikponji amame shikpon ni amechon gbeno ne sana amechon ni neke no ko na ame ba bayi ame fe na kan no. No acts of ownership and possession of the Sowutuom lands was shown by the plaintiffs. Plaintiffs do not show that they had anything to do with the Sowutuom lands. Yeah, once again, I mean, ni femo ko kla be ni makwano ni maya wo mi ake neke ni femo ne echomi ake neke shikpon ne Josh bia no ame fe no ko kla ni tomona kan ni ba ni maya wo mi ake Sowutuom shikpon jinye amame no. On the evidence as a whole, the plaintiffs cannot succeed in their claims against the defendants as per their writ of summons in the matter. Na nibi na ke ba hwe yin fe ken kwa no jogba no kokura bemi ni cho ake Josh bi amenya ametron ake ne ke Sowutuom shikponji ne amame no ni. The plaintiffs have surprised this court that there are important steps one would have expected the plaintiffs to take, which they refuse to take and do not respect their legal implications. Josh bi aye fele na pe. Akeke lela ke shikponji ne amame no ni. Ibi pi ye ne sani chukwu amefe. Shi ke amefe ne ke ni bi ne fe. Amefe ne ke ni bi ne. For example, example. The plaintiff's judgments they had were never respected by them. Neke judgments na me nyenye na me ke eje privy council ke ni bi efe ame Josh bi e de nche ame bu na kan judgment say. The judgments were not registered with the Lands Commission. Am I registered na kan judgment say with the Lands Commission? Abola Piam bi benyen kaseli ye. Neke judgment jine fe na kan kendo go ye na asane nye fe benyen fe. Keji o represent or stool ko ka obomito e bebe wo kan kaseni benyen kwanya wo jiami. Benyen kwanya wo jiami. Nyen kwanya wo jiami. Nke ene me no ba chawo. No ba chagan. No benyen kwanya wo jiami. Benyen fe ni bi ne asane nye fe. Benyen fe ni bi ne asane nye fe. Nye ya anya afia ni bi. Ka obomito e no je sempe. Oje akamaji. Oje asene. Oje gbese. Oje otubloun. Oje lantejanwe efe no je ka obomitwe boka cheme nwe wana judgment ye bi ani wa register Lands Commission lo wakete ni Lands Commission ba kweno na meke shikpon ba wo gba mi be obomitwe be no obomitwe be o chuni ye ka obomitwe keke no te no agbasane no ke o ni tete kande ni efe ni wona ke so dabi bon ya bi o cheme ake judgments ji na me nye ama register with the Lands Commission lo ya no abi. No acts of ownership and possession of lands identified in the documents they had some many years ago have been effected, and yet they are actions that are barred. I'm judging kake ne keni bi ne fe ni judgments ye fe na amena ame effective ekokula. Now, judging kake mi ne ko eke section 5(2) of NRCD 54 provides that a person shall not bring dabi iwonokoyi dabi iwonokoyi amaka ne bi ene iwonokoyi NRCD 54 Limitation Act 1972 section 5 and 10 are relevant and important. Section 5(2) of NRCD 54 provides that a person shall not bring an action on a judgment after the expiration of 12 years from the date on which the judgment became enforceable. Ke ye dansoma no kwemi o ye English alata no kwemi jeje kebo no kwebie you have 12 years ko na judgment kwe to make sure ke oba enforce na kan judgment work on it, register it with the Lands Commission. Shukon Sunday e gbla wote anchon. Section 10 of NRCD 54 also deals with the recovery of land. Section 10(1) of RCD 54 provides that a person shall not bring an action to recover land after the expiration of 12 years from the date on which the right of action accrued to the person bringing it, or if it is first accrued to a person through whom the first mentioned claims to that person. Section 10.2 also provides that a right of action to recover lands does not accrue unless the land is in the possession of a person in whose favor the period of limitation can run. The plaintiffs have not shown whatever they did with the Sowutuom lands in giving effect to the judgments they had in the past years from the 1950s to the last periods. No ownership, no possession of the lands have been effectively shown by the plaintiffs. The third defendant, Ni Oma Mensah Family Limited, filed a statement of defense on 28 November 2006 at a time when the plaintiffs had nothing to do with the third defendant. The plaintiffs gave no evidence against the third defendant and stated that they had not sued the third defendant. It is not disputed that the operations of the third defendant is protected by statute, and the plaintiffs cannot interfere with the interest of the third defendant. The land in contention by the third defendant has not been challenged by the plaintiffs, and evidence before the court is that the land the third defendant is concerned with does not belong to the plaintiffs, and the plaintiffs have not challenged the third defendant on the ownership of the land. The land belongs to the state, and no one is challenging this, and it is from the state that the third defendant is able to operate on or from the land identified by the third defendant and not questioned by plaintiffs. The land on which the third defendant operates is land compulsorily acquired by the state by virtue of EI-18 and EI-10, as confirmed by the third defendant, and the plaintiffs have not challenged the third defendant on this. In effect, the land in question continues to be with the state, and the third defendant will continue its work on the land as would be directed by the government. It is clear from the above that the second defendant is the allodier. Once again, judge and confirm it is clear from the above that the second defendant, Abola Piam, is the allodier and true owner of the land in dispute. And the land in dispute is the ancestral settlement of the second defendant who migrated with the guns from Ayawaso. It has not been shown that Asere's tool has been in uninterrupted possession of the land in dispute from time immemorial. Asere me nyeko ne ba chon nyake ke jobu ade amame yishikpon no a oni mogomogo gbakwa me na. Asere me nyeko ni ameba chon me na ke. The evidence also showed that the first defendant lawfully acquired the notice of the declaration by the second defendant registered as number 1529/1969 had been given to the general public, including the plaintiffs, to enable any objection from the true owners, but there was no objection raised by the plaintiffs and any other interested group. Abola Piam be ameke before na me ba register kena me register tan ameke ni efen meshi ni moko kamoko ye noko yue moshimo ni moko mo aba yue moko eba yue noko eshi na kan no. The evidence also showed that the statutory declaration registered as number 1529/1969 and stamped as AC2AH7/69 was not secret. It was not fraudulent. It was not illegal. Or null and void. The statutory declaration was valid and of legal effect to the benefit of the second defendant and those who took advantage of it, such as the first defendant. The first defendant caused the demolition of all trespassers' buildings on its land through state agencies that are power to do so and remained in possession of the land in dispute without let or hindrance. The next suit is BL 143/2005 what be na water yes about repeat most of the things fam our visitation ke Dr. Isaac Abebio be owner Josh bi ehun kamete ni ame fe now. The issues raised in the suit at the close of pleadings for determination were whether or not the plaintiff is the owner is pretty much the same thing. Let's go to what the judge said. How long have I been sitting and reading? Whoa, I've been reading for about 4 freaking hours. That's a long time. Oh my goodness. I've been reading for about 4 hours, right? Get OJ 18 hours for introduction and intro. So at least for about 4 hours I've been talking. What about you? Ni about you? All right, let's go on. Let's go on to Noni Jia. And this is the final one. So let's go on. So enemy fan can but let me read it again. Judge repeat it. The plaintiff did not give any evidence against the defendants on the land in this dispute. The defendant gave its evidence through Grace Abebio, an evangelist who told the court that she is on Sowutuom land, which on 22nd August 1979 they acquired from the Abola Piam family. They were given an indenture which was duly registered with the Lands Commission. She tendered the document indenture Exhibit 29, which was granted by the Abola Piam family to the hour of visitation, which has been on the land since it was acquired. And on the land, they have drawn electricity through the Electricity Corporation of Ghana after paying for the transformer, which was put on the land at a cost of 50 million cedis. She continued that they planted mango, thick cashew, oranges, grapefruits on the land. She built 2 bedrooms, which has been turned into a nursery school and partly accommodation, a 4-classroom block and uncompleted block used for dining hall for the children are also on the land. That the school built on the land is in operation and that the land does not belong to the plaintiff. She tendered Exhibit 29, the indenture showing that the land was validly alienated on 22nd August 1979 to our visitation and Dr. Isaac Abebio by the Abola Piam family. A search was conducted on the Lands Commission by the defendants where the search report showed that the land belonged to the Abola Piam family. The Abola Piam family's representative testified that the family validly gave the land to the hour of visitation and Dr. Isaac Abebio, as shown in Exhibit 29. It is clear that the hour of visitation and Dr. Isaac Abebio proved ownership of the land in contention and also showed possession of the land in dispute. The documentary evidence shown in Exhibit 29 and the oral evidence that justified the ownership and possession of the land in dispute by the defendants were overwhelmed and could not be challenged, thus showing that the claim of the defendants in the matter that the land belongs to them should be upheld. The documentary evidence and oral evidence are all in favor of her of visitation and Dr. Isaac Abebio, and I so uphold. Once again, the plaintiff failed to prove his title to the land in dispute, and this case is dismissed. In effect, the plaintiff is not the owner of the land in dispute and its surrounding areas. The defendants are the owners of the land in dispute. The court's judgments mentioned by the plaintiffs in the statement of claim and the defense of counterclaim do not affect the land in dispute. The deed of conveyance registered as number 2251/1986 is not null and void. It is indeed valid. Now, conclusion. Now, in the premises, all the reliefs for the plaintiffs in both suits BL 143/2005 and BL 397/2006, consolidated as BL 19/2010 TRS, are hereby dismissed. This is basically due to the fact that the plaintiff have not led any credible evidence to prove their case in both suits. Because Joshi B ameke nomi ma nibi ko klaba ni ba ni ma he amesande awomi. Counterclaim. The counterclaims for defendants are for judgments as follows. Seal number BL397/2006. In the premises, there will be the judgment for first and second deferment as follows. Declaration. So no counter claim and Abola Piam pretty much declaration confirming the second defendant's family, the Abola Piam family's title to all that piece and parcel of land bounded on the northwest by Insaki River, on the north by Ofanko and Asofan villages, on the southeast by Kwashiman or Asere's 2 lands, on the east by Onomroko Adai and Awulemona family lands, on the west by Ablekuma and Anya villages, measuring approximately 6,698.726 acres. It is clear that the hour of visitation and Dr. Isaac Abebio proved ownership of the land in contention and also showed possession of the land in dispute. The documentary evidence shown in Exhibit 29 and the oral evidence that justified the ownership and possession of the land in dispute by the defendants were overwhelmed and could not be challenged, thus showing that the claim of the defendants in the matter that the land belongs to them should be upheld. The documentary evidence and oral evidence are all in favor of our visitation and Dr. Isaac Abebio, and I so uphold. The plaintiff failed to prove his title to the land in dispute, and his case is dismissed. In effect, the plaintiff is not the owner of the land in dispute and its surrounding areas. The defendants are the owners of the land in dispute. The court judgments mentioned by the plaintiffs in this statement of claim and the defense of counterclaim do not affect the land in dispute. The deed of conveyance registered as number 2251/1986 is not null and void. It is indeed valid. Conclusion. In the premises, all the reliefs for the plaintiffs in both suits BL143/2005 and BL397/2006 consolidated as BL19/210 TRS are hereby dismissed. This is basically due to the fact that the plaintiffs have not led any credible evidence to prove their cases in both suits. Esani ayayo sanekokla yega traditional council about Sowutuom shiponji kotu e decide yomo. Esani ayayo sanekokla yega traditional council about Sowutuom shiponji kotu e decide omo. The traditional council is a quasi judicial body. A be a wale for the main judicial body. The traditional council nye tasane no ni kotu esta no mo ne decide yomo. Esa mi yue kong ike esa ni ayayo sane kokla ye the traditional council. Yeshiko ni yo Sowutuom ye. Kotu dienche e decide yomo. The traditional council ame be wale ni ame ba yue Sowutuom shikpoji insande. They don't have that power. I'm repeating it again. The traditional council nye be e wale ni nye ba yue Sowutuom shikpoji insande. Kotu e decide moni shikpo le no ni yomo. Kotu e decide yomo. Nye be no ko yue mo ye. Mrs. Ashon, nous tumo ona ke nous tumo e bolebo. Mrs. Ashon e use word here. The whistle. Ona our wife kase nous tumo come e use word here. God traditional council. Mrs. Ashon ken Kenya ke ye be capacity. God traditional council. Mrs. Ashonke in Kenya ke nye be capacity nye ba yue Sowutuom shikponji asande. Court we decide e cho money shikpon le no ni omo. Nye be capacity. Over there, like him show am yonu. Kiamogo. What be na water? I don't know if Chame was mona maybe. Me no she be. Me na the whistle we be. Anyways, I don't know any what for. Mrs. Agent. How far are you from Shianshe? Okay. The counter claims for the defendants are for judgments as follows. Suit number BL 397/2006. In the premises, there will be judgment for first and second defendant as follows. Declaration confirming the second defendant's family, the Abola Piam family's title to all the piece and parcel of land bounded on the northwest by Insaki River, on the north by Ofankor and Asofan villages, on the southeast by Kushiman's two lands, on the east by Onamrakwadine and Awule Mona family lands, on the west by Blekuma and Anya villages, measuring approximately. So, once again, a fairly clear. I can shiko GFM. Acres, which is reflected in the statutory declaration made on 24th March 1969, registered at the land registry as number 1529/1969, and stamped as number AC288769. An order declaring the alienation. Okay, thank you. An order, Moko sending me voice note. We can try live, so can be near Kanimona, and Benanta, Makani. An order declaring. One second. The whistle. Over there, come on phone and am you. An order declaring the alienation of land made to the first defendant by the second defendant's family as valid. An order of perpetual injunction to restrain the plaintiffs, the agents, assigns, privies, servants, workers, whomsoever or otherwise, howsoever, from interfering or dealing with the land described in paragraph 31 A, supra, or any portion of it. General damages for trespass at 2,000 Ghana cedis. Counterclaim for defendants in suit number BB Achajameko. Declaration confirming the piece of land of situate lying and being a Sowutuom residential estate layout, Accra Northwest, Sector 3, and bounded on the north by proposed road measuring 830 feet more or less on the south by proposed road, and measuring 860 feet more or less on the east, more or less on the west by proposed road, measuring 490 feet more or less, and containing approximate area of 9.11 acres more or less. Akwete asking for cost of 50,000 each in the first suit. Second suit with Dr. Abebio is also asking for 50,000 from each of the. Nana said we are also asking for cost 50,000 as our learned fine ask by court. I've heard counsel for the defendants in the consolidated cases asking for costs to be awarded. I recognize that the parties in the matter are not antagonistic to each other. The parties are here for the assistance of the court, and this court has done what it could to assist in the matter. In effect, the court will award cost in favor of the parties that won as follows. So, court award cost against Minachole, Josh BM. The judgment/creditors in suit number BL143 are awarded cost of 5,000 each. Judgments are credited in suit number awarded cost of 5,000 each. Signed, Alaji, Justice Abdullah Idrisu, Justice of the High Court. So, I think this is about it, right? Let me say this one. I'm quite this attachment. Let's see what this attachment is. Once again, describe land there, so I don't think it's that important. So this was yeah. Yes, lands registry registration no jinoni on screen there no. We do not have to read that. So listen. Clearly. Mina chole. Sowutuom. Okay, okay, Mrs. Ashonke, Eshofi ba shebi ke shebi no makpa. So nya ni wotwa meye nyoko. Let's see. Hello, Uncle Johnny.
Hello.
Papa, how far to your turn?
Bani tete prosecutor general.
Ah umpa.
Nutumole o tunleto.
Ow.
Wanda bochuwa jenche.
Yow.
Lady Agbo ko ose shife.
Yow.
Lady Agbo the whistle.
Yow.
Producer extraordinaire.
That's right.
Birthday boy.
That's right. That's right.
Mrs. Asere.
That's
you
right.
have job.
Yeah.
Ake o husband room.
That's right.
Ni etru onitumo na ke wagafe.
Yeah.
Many between Kevin Giordano, so try that will view say.
That's right.
In what are for in the cheme beggar. Based on it being o jepo efe cheme beggar. When behavior come a conflict of interest.
Yep.
Then additional counsel, almost all of them are conflicted in this case.
Exactly.
Create artificial division between Oman Joke Sowutuom. Me simply step aside and recuse him from this case.
Exactly.
Because he is highly conflicted.
Yep.
Cannot go court. We get any time na ke excuse justice must be seen to be done and must be manifestly done.
Exactly.
Two groups I have a clash. When Namoni Saniku Amefe Cheme, Amasla one faction. Almost 1 year, Ebaho.
Yep.
Na cheko and na chapman victims but one nanoni many failure one aka achame. It was a purely criminal case.
Yep.
This I'm a fair Germany. O conclusion that traditional council is a quasi judicial body. Court many court
That's it.
Simplicity.
No, Agbena.
Munakebatu ni onyo ya wo manche tamukushiponi na afio neye.
Dabi.
Ono no ngeche mebega.
Yep.
Because unake ashe game ku. No be papa yo. Si papa yo eso be fio.
Naga ona.
Ebe chasali vi nega yo automobile mete down.
Vi mete ona.
Papa yo be la go say no go gi la yo.
David. That's right.
So no can miss.
That's right. Let fire.
I mean America the Sanyami. Oman is not different from Sowutuom.
Dabi.
Abola Piam be ameteshi.
That's right.
They know blind here can me a share gonna friend me push.
Oh, mpa.
Because maybe come was task a few. So yeah, I was 6 batch 9.
Yep.
You are Mufiamu. I am back.
That's right.
Aqua. Chimoni ya no what penny was bad some by Yazuli.
Dabi.
Because she's from anyone after one side.
That's right.
Koje Abola Piam ya wobu manche ya Abola Piam Chipono.
Dabi.
Like ABCD.
No.
No financial contribution.
Thank you so much. Naga, Radon.
Can your judgment to my tububa?
Oh, I feel there. That's right. Thank you so much, Uncle John. Yeah. Right. So, producer ke manyamacha audio. So, nyani matra mahanye. Eke agbene nke cheme baba minna ayabache biye minna okanleche. Akuche o ebiye yodabi ayeleche mo yobi okanleche ili aka okanleche biye. Okay. Yes, over the mimba matra babu onu producer ke manyamacha so mimba matra.
Ago cheme kenyeme nime kename. Numwe ke chokuno twalwe. Asla foi ministers, lawyers, mancheme ke manyeme. Numwe fe ni na ikpishe pamaneno. Uomwe ke woyi. Ni banye do maye. Akeka batu ipe ingbe na amali. Ne lukunu li etomodun. Ongene mita ni mofiamu anali. Ake sande kashi omanjo. Ni sande kashi omanjo. Ni kwebe ni bafi ni amo sande nena. Ni Sowutuom mekebiye jo Sowutuom na meba. Ni meni ba fe kaje aigbe mabi sonu mabi. Kwa ache ake asa Larry. Kwa ache agereshi Johnny Roadmaster. Kwa ache age Sadiki Rauf Eochami. Kwa ache Boyson Nacho. Ni moni petese ni echuame na ebafio na kanie. Ji Sowutuom manye bile na mechole pato leo se ne yemo na meke baji traditional council ke ni o manjo first mancheni shibiane je mancheni no muku kelaka chuni ye mam be aje Sowutuom na ba manjo baba finu na ametuisumo ni woyeje ofe woyeje no ani shishije yuade shika gbatu ipe ngbe na amane woyeje ni wonye wota shidane na mba finu na afio yo manjo wonye wota shidane meni holose na mechuame na mba finu na mba fie amechame na amekama yui ya gashimie yue mo fe ko isumo ne ba mami ni mo fi ama anu no ni ya no so ni sane ba na akwe sane ni amenwu ne kai bi olu ani ametawo ejole acheme alo ametawo na agba acheme lewo achame na kama yui mo fi amo eye ame bonyo wumi mo fiamo ye ame eye aka egbonyo wumi no kanye yuo eja gashi the moment ne kulo ba ekusun ye o manjo ni won wo baba ni ba fi crashing no kunkuru baba pe abaga shimini ata na mo sande na sande ejo wa kama yue na me pa o manjo ba na me pa no na me ba fi yo manjo ne try no man yabla.
You see the nonsense that we sit here and we talk about? Bona. Okay. Moko naturally, Mr. Loti, you would come under my video and then Obakake, why do I hate Kevin Taki so much? I don't know the guy from Adam. You don't know me as a person. But these are the nonsense. Nick come from a camper. Nimi inkechuni. And when you want me to like Nekenibi Komena Fio from Kevin Taki a camper. The traditional council, I'm a bay wale. Ni I'm a back chon Abola Piam in be money esani eye manche ehame. The traditional council eto manche. Newa the traditional council enye eta manche. Some of you are so stupid. It's unbelievable. You are so fucking blinded. And when we talk about some of these things, the unique poops again you banye bulu bulu. The traditional council, I'm a bay wale. I'm a to manche. So I'm a bay wale. Nika Abola Piami eto manche kwe. I'm a backpacker manche. No backpacker manche. J manche ni don. We'll deal with this tomorrow. One anonymous can you far. It's only 14 pages. Making about what can you almost 50 pages or so. What can you? What 14 pages? We'll deal with this. Nyanin kechema about 1 minute. Madam Eba is ani wajepo. So minpa if inyema tramukodo. What we can make some phone calls tomorrow. But nyanin kechema about oni what 1 minute ko pe ni what kwani what may. Over 1 minute quickly. Minia.
Nimba manye mo family. Me te bo you are don. Misalo te kema elu ebemi dan. Misalo te hanele ake elu wa elu kemaje. Elu alu le yemumomi. Ke mi elu le yemumomi. Ke ayo manjo sande. Ke Sowutuom ni amefe ekobe ni achon ablona bo oba bado ba you no you are him na help Kevin Taki ejomo gba etashi afi na eme ni bo nye fenye luluye wo elunye ni anya foundations mi ake misalo say e gba ye don ke be no ko me set hela ke be no ko sensible you boni go be ke la kase ni misalo te ejeje ene pe di ni le je kase ni nation le ni lulo ani mo ko to ayi ni tete
Eje ayeleje awon wo I let you yeah. You are Dromo. Or fair word you are. Oh, Ona. She, over I was so true and she attacked him with Dubai or breaky. Catch you and show Dubai.
Embassy never call me, Jenta, they will you or I see. We monitor our first any yano. Ona, ya you was so. Your choice. Ona, you are job. Ojoban, abo you want. Yeah, Luchumoni, Uchum, the Persian Magu, on your obla. Nonichi emling ojuban ke amoko femoko ni ta flache e bo meaning we trane o the musician ni pa ma wi peji ni ko lai amashie e bo moden imbere e ho komi fa e bo moden ni ese bi e acha ma tashin le ka ma wi o the musician ni ke jomo awa me chi am because no me come je no money ni bi e come happen ni don't know can in fe mo fiam bring me trying a mon nagashi. No fellow is just clear. Clear.
Right.
What do you mean? No, Sunday ania equani I'm a late. Ne equani to fetch it. I'm a budget metneko. Equani I'm a echo woman nushi. No, and every morning nature me pay. On any economy a charm. The money allo after video kehame. Then I try bedroom be yet to order me see to a choir master. Be a choice a yellow na melini ora ege ado babu na ka ni yetu bi am de ke legimanche bi ani ni tu san de tu dino for about me shi you come de tu na ka no tu mo ke tu na ka no tu mo e ba wa ege mo fia mo tu ejo ora me shi no fia oni yo mu ne
ishe o right on I ba che ka wa pa
Tete oira don ke benu ha wo da no question wo mo ye gan. Timere ni me mimba yen fen de omanye
abla wo fen.
Imba ni na program FM mo nshi. No ni poni imba ni na ye mingbe fa I don't think there's any dispute. Spon money on me. Abola Piam spon. Thoughting we obashi Abola Piam spon. E wo taflache meni yo se alo meni ka me peli o here. Sina amena ni kasemo ke jomo ni ne ni eshu on agashi amecheme ni amanye ne ke sponsor ne amelefa agashi je amamishmoni Abola Piam sponsor e wenele je people we money
that's right
anukwale e fan e wo wonda bo shagashi onye ogbami awo fe ni wona enya anukwale ka ni woli anukwale
that's right
no makeji ndete ene my shift topic if you ke shi mi esani ma yue ni imbo atu na efe no ni njonji au kenji wa anyi wo broadcast no fi one ye Ghana wo nye manu mena no ji no komeni a country no wa denche
yeah
wo igwagme wo kwelo ahi agashi kamele ameteme kume ame connections you amele en muku alome ni chuni radio station say alo TV station say ni ba anye ni wona egbe ni wo broadcast o program na no no ba wa denche ya ke the flat che wonye me pi ni no ni oji ne amenu amele amena e ko na ma kan ni
yeah
ika amenu na mena ndete dumo pi bata ke ga
yeah
dumo pi bata ke ga no ni wo la ko ye ni Nigeria ke ta flat wonye me mbejomo
that's right
allo amsumoni kasemo see they don't have access nkwa mo fe mo yi ni lele ne guess mo ga ne ta ga ya yi ichi mo no chu e bi e ntete chu e bi e no ni ba kpo gan o ke o ba na ka access ngo ji no fi o ne TV no age gan ntete gan ba chake
that's right
gan ba chake e wo no yi fi o ni yo ni mo wi o ra don LLN people ku pe na ba wi
thank you so much tumo beni nke bo mene what deal with Asere versus Abola wo oba deal with mina chole Sempe versus Abola na kind no you start with any because any a very detailed a lot of story agbasani ojugba ade that is why Sempe no both the one from the High Court, Appellate Court, if I think it's only about 14 or so pages long. So what I be no I deal with no. And now, like, look, to the bloggers out there, look, you are free at liberty. Download the video, post it. I will not do anything. If you really want to help the cause, if you really want to help the cause, ni o tao ni o wa gandang be. Can fair video download it, post it on your platform. If you know if you really because look, I understand some of the things so when you share me ma you can you poster ni nyeka wa can you na can you jomo yemi na no kwale ni you poster so a lot of you have bigger platforms as well. You are free. Download it, post it. But I don't know. Online platforms, Facebook, like I said, download my videos, post it. You will not have any problem with me. Then you download on your videos, come and get your shows. So download the money, post it, share more. Call your TikTok account. No, but no flow. Come flow mo no post it again. Or your Instagram account, Twitter account. No, but no chop here, chop him. Ni opposti in bed they can each one done in fear. So now they can name lenche matashi, they can chop here come again me. So everybody is free to use my videos. Just go ahead and use it. Cheme, you wanna don't mo money. Okay, pushing. Yeah, no, real quick.
Yeah. At that when you if you're based upon my experience in a Kehacha Community each one I mean not judgment there. Instead, this I'm a court back on a new I'm asking for
enforcement
the content of the government. I'm a more see I'm a book a lot, but I mean yeah, beep.
Yeah.
Now can't have judgment there. The fact that no, I can't no, I was on I. All the me she hands, I caught their back.
Yeah.
All the me she caught I grant you permission. The content of the judgment there, on your boy execution film.
That's right.
All the me she. No, who can do? Open up here now and name.
Yep.
Don't find a fit I am.
Ishe. That's right. Ishe. So nye bo amode nye enforcer nye court nye sika nye enforcer na kana oba bia nwo ni woba cha no nye fenye yi ana walada oba kpe bia wo bye bye.